All right, everyone. Good morning. I hope that everyone had a happy holiday, or as we call it in Louisiana, happy Easter. So I am back from a week away. So just to remind everyone of the rules of the 187 District Court, you are in a courtroom. If you do not behave appropriately, your Zoom privileges are going to be revoked. Today is Monday. It's a little cloudy out there, but as my mom always says, April showers bring May flowers. So your grass is getting watered. So it's going to be a beautiful day. So let's not make it a difficult Monday. Let's keep it a happy Monday. It's time for new beginnings. I'm going to open breakout rooms. When I open the breakout rooms, it's going to invite everyone to go to a breakout room. Do not, I repeat, do not go to a breakout room unless I specifically call you by name and assign you to a breakout room. To all the defendants, your attorney is going to probably want to go to a breakout room with the prosecutor before they go to a breakout room with you. So please do not raise your hand and ask if somebody wants you in that breakout room, because if they did not request you, they don't want you in the breakout room. To all the inmates at the jail, you are not allowed to use the chat box. You're not allowed to use the internet. Attorneys, do not have your client using the chat box because they're not allowed to use the chat box. If they use the chat box, the deputy is going to see they're using the chat box and they're going to send them back. So inmates, if your attorney asks you to use the chat box, tell them the judge said you cannot use the chat box. To all attorneys, when you're talking to your clients, if they are in custody, do not, I repeat, do not leave them in a breakout room by themselves. Even if you're just coming back to say, we have an agreement, because if they are in a breakout room by themselves, the deputy is going to assume that they're done and they are going to remove them. And it's going to take us a while to get them back. To everyone, you are not, I repeat, you are not excused until I excuse you. So your attorney cannot excuse you. The coordinator cannot excuse you. I'm the only person who can excuse you. To all attorneys, to make assigning you to the breakout rooms go well. As you can see what Mr. Brooks has done, he remembers all the rules, and Mr. Slimane knows it. And Albert Gutierrez has been here numerous times. I don't know why he doesn't remember, but I've been gone for a week. So attorneys, to your name, add the name of your client. And when you add the name of your client, add whether or not it's family violence or criminal trial division. The way to do that, go to participants, click on your name, and then click the more box, and it will show you, it will ask, do you want to rename? Thank you, Albert. It'll ask if you want to rename yourself, then do it. All right, to all of those who are accused, your name will not be called. Your attorney's name will be called. If you do not hear your attorney's name, it's because your attorney is probably Zooming in another courtroom or had to appear in person because people think COVID is over and doesn't no longer exist or never happened. So just be patient. Attorneys, this is the order in which you will appear. If you see that you are low on the list and you wish to Zoom to another courtroom or go to another courtroom, you may do so. However, the court is taking its break at 12:30. So attorneys, this is the order in which you'll appear. Albert Gutierrez, Linda Corley, Nathan Slimane, Regina Tibbs, Sophia Martinez, good seeing you, Ms. Martinez, Tim Molina, Christian Greer, John Distrew, Will Brooks, Eric DeWalt, Chase Butler. Is there any attorney who's on the Zoom screen that I've missed? All right, to all those accused.
Yes, Your Honor, I apologize. I'm interrupting. My name is Jeremy Best. I am an attorney. I was reset from Friday.
All right, thank you. To all the attorneys. If you have an agreement, no matter how small you think that agreement is, you need to put it in the chat box to Ms. Ferguson and to the prosecutors. If your client is on bond, they need your client's email address. We only have one clerk now. The other clerk has gone on to greener pastures. He's working at a bank, is what I'm being told. So your paperwork is going to go to Guadalupe Leza, as you all know him as Lupe. That's who you'll be sending your paperwork to. To those who are accused and those who are at the jail, you are in a courtroom. You are not allowed to be doing laundry, be doing chores, Zooming and driving. None of that is allowed. You are not allowed to be eating breakfast. I did not have breakfast this morning. I'm sure everybody would love to have had a nice long breakfast, but we didn't. We're here. Do not do any of these things. You are not allowed to be smoking or vaping or drinking alcohol or laying in bed. None of that is allowed on Zoom screen. If you do any of those things, your Zoom privileges will be revoked. To all of those who are on bond, your screen can only go dark for 2 reasons. Well, maybe 3 reasons. 1, there's an issue with your internet connection. 2, somebody has called you on the phone, in which case you need to immediately decline that conversation because you're in a courtroom. Or 3, you're signing paperwork. Those are the only reasons for your screen to go dark. If you violate any of the rules of this Zoom, if you behave inappropriately on Zoom, there will be no questions asked. You will be required to appear in person in the 187th District Court located at 300 De La Rosa on the 4th floor. That means that you're going to have to get an Uber or a Lyft or take the Via Bus. The Via Bus still does not give change back. So that Via Bus ride is probably going to cost you $10 to $20. If you drive downtown, you're going to find a lot of one-ways. And if you're blessed and able to find parking, you're going to find parking is very expensive. I just saw a sign for parking for $25. So do not make this a difficult Monday. Let's put smiles on our faces. It's going to be fabulous today. So Albert Gutierrez, I'm going to send you to breakout room number 3.
Thank you, Your Honor.
Excuse me, Judge.
Yes.
You asked if there was other attorneys and then you started talking. I'm here in your courtroom.
Oh, I see you. I have you on the list.
Thank you, Your Honor.
You're welcome. My vision is not what it used to be, but it's not that bad. Linda Corley, I'm going to send you to breakout room number 4.
Thank you, Judge.
Nathan Slemain, I'm going to send you to number 5. Regina Tibbs, I'm going to send you to number 6.
Thank you, Judge.
You're welcome. Sophia Martinez, I'm going to send you to number 7.
Thank you, Judge.
You're welcome. Tim Molina, I'm going to send you to number 8.
Thank you.
You're welcome. Christian Greer. Christian Greer. Going once, going twice, 3 times. John Disrude.
Morning, Judge.
All right, I'm going to send you to number 9.
That was great. Thank you, Judge.
Will Brooks, I'm going to send you to number 10.
Judge, I don't know if I need a breakout room. I think we have paperwork on Mr. Luna, and then my other client I do not see.
All right. Just 1 second. We'll check on your paperwork. I'm going to send you to breakout room number 1, and we'll see. Where is Stephen Rhodes? Stephen Rhodes. All right. What about Matthew Luna, Mr. Brooks?
He's present, Judge, and that should be the paperwork case.
All right. Matthew Luna.
Yes, ma'am.
Let me see. I'm going to send you to a breakout room number 1. Will Brooks, I'm going to send you to number 1. To the clerks, if you could go to breakout room number 1, please, to make sure they have all their paperwork.
Thank you, Judge.
Eric DeWalt, I'm going to send you to number 9.
Yes, Your Honor, there's 2 cases. One's an MTR. I have not received a copy of that MTR yet.
All right, if you'll put it in the chat box, your email address to the CLO, she's listed as CLO Reyes. She'll get that paperwork to you.
Thank you, Judge.
You're welcome. Chase Butler.
Good morning, Judge.
Good morning. I'm going to send you to number 10.
Thank you.
All right, and Hopkins. right, Ms. Hopkins, who is your attorney? All right, Ms. Ferguson, who is Hopkins' attorney?
It's in the chat, Judge.
Thank you. All right, Jeremy Best, I'm going to send you to number 11.
Thanks, Judge.
You're welcome. Andres Campion,
Yes, good morning, Your Honor.
good morning. I'm going to send you to number 12.
All righty, thank you very much.
You're welcome. Richard Garcia,
Good morning, Judge. How are you?
how are you? Are you back?
I am, unfortunately.
So what is your client's name?
It is Joe B. Pope.
Criminal Trial Division or Family Violence?
It is Trial Division.
All right, well, your photos were beautiful.
Thank you.
All right, I'm going to send you to number 13. That's the lucky breakout room.
Okay.
All right, Stephen Redgate, have you had a chance to speak with your attorney? I mean, sorry, with your client? Stephen Redgate. Ms. Ferguson, would you like to call Mr. Redgate and let him know that this person is calling in from an out-of-county jail, so he needs to be here? James Hunt?
Yes, Judge.
Yes, what is your client's name?
Roberto Martinez.
Criminal Trial Division or Family Violence?
Criminal Trial Division.
All right, I'm gonna send you to number 14.
Thank you.
George Schaefer, who do you have?
His name Jesse Esparza.
All right, is it Criminal Trial Division or Family Violence?
I believe it's criminal trial, Judge. I had last spoken with Michelle Hayden on the case.
Okay. You say Jesse Esparza?
Yes,
All right, that's Family Violence if you spoke with Hayden.
okay.
I'm gonna send you to number 15.
Thank you, Your Honor.
You're welcome. Neil Kalfas?
I have Darren Dozier, Your Honor, family violence, last conferred with Michelle Hayden.
Okay. All right, I'm gonna send you to number 16.
Thank you.
You're welcome. Is there any attorney who has not been assigned? All right, and Ms. Ferguson, do you have an update on Stephen Redgate?
No, ma'am, I'm still trying to get a hold of him, Judge.
Nathaniel Navy, who do you have?
Ashley Castillo, Judge. It's a family violence case. And I was conferring with Michael last week.
All right, I'll send you to number 17.
Thank you.
Judge, I just sent you a chat.
All right, thank you. I'm opening up the email to look at that. All right, who is this Tyrese person with the braids? Stand up. What is your full name?
It's Tyrese Hilliard-Smith.
All right, you need to find a location and you need to sit there and you need to sit up straight. Do you understand?
Yes, ma'am.
But they would need our mask on when we're coming back here. All right, thanks. Stephen Redgate.
Good morning.
Stephen Redgate. Good morning.
Your Honor, I've been here since 8:30, but it kept refusing to allow me to enter to turn on my video.
Docket starts at 9.
I know,
So
but
I'm
I've been here since it wouldn't allow me in. I had to turn off my phone and restart it to get back over there. I apologize to the court, but I have been sitting there. I heard you call me, and that's why I eventually had to just shut off my phone and start it all over.
Okay. Do you need to speak with your client or do you need to speak to a prosecutor?
To the prosecutor real quickly, Your Honor.
What is your client's name?
Rosa Madrano, Your Honor. She's at Hopkins.
Criminal Trial Division or Family Violence?
Criminal Trial Division, Your Honor.
All right, I'm going to send you to breakout room number 2.
Thank you, Your Honor.
Were you conferring with the specific prosecutor?
Yes, Mr. Sanders, Your Honor.
All right, I'll send you to number 2.
Okay, thank you very much, Your Honor.
You're welcome. And Rebecca, I have your message. My computer is just working slow today.
Okay, thank you, Judge.
You're welcome. Henry Knight. James Hunt.
Yes, Judge.
You're back.
I got knocked out of the room. I was
What
in
is your
14, I
client's
believe.
name?
Roberto Martinez.
Criminal Trial Division or Family Violence?
Criminal Trial Division.
I'm sorry, Judge. I was trying to get it off mute. I was confused. I'm so sorry.
That's okay. For everyone, we've been doing Zoom for over 2 years now. If you cannot work your Zoom, then we've tried all we can try. You got to start appearing in person in court.
Yes, ma'am.
All right, Mr. Victor Fernandez. All right, if you're going to unmute for me, please. All right.
Hello, Your Honor.
Hello, how are you doing this morning?
Great, Your Honor.
All right, Mr. Fernandez, we have an issue.
Yes,
And the issue is that restitution is owed.
yes.
And your restitution is $248,000.
Yes, Your Honor.
So,
I have stock or shares in this company. They're helicopters that run off hydrogen. And the company is brand new. And I purchased 300,000 shares. So if it even goes public at $1, I'll have $300,000. But they're estimating it at between $15 and $20 when it goes public. And that's the main thing I'm waiting on.
I understand you're waiting on certain things, but certain things may never happen. So how much are you making? Because I see that you're part-time.
Yes, I make between 1,500. Well, some months 1,500.
All right, so here's the thing. You're going to have to start paying more money than what you're paying towards restitution.
Okay.
I mean, you know, people always wait for money in. At least if you say you're waiting for income tax, we know there's a certain date when that may be in. But waiting for a company to go public and then selling your shares and see who's buying your shares, that may never happen. So what you're going to have to do is you are going to have to get a full-time job. And if that is 2 part-times to make it a full-time, great. If this part-time job is supporting your basic needs, then when you get that second part-time job, all of that money should go towards restitution.
Yes, Your Honor.
I understand the plight that people have with regards to money, but guess what? The person who's owed the money, who's a victim, they have a plight too.
Yes.
They now have over 200,000 in debt because of you. So you're going to have to get another job and you're going to have to start paying towards that. Do you understand?
Yes, Your Honor.
So Rebecca, on Victor Fernandez.
Yes, ma'am.
He needs to get another part-time job and within 20 days, you're going to report back to me on your job. You understand?
Yes, Your Honor.
Ms. Ferguson, can I have a 20-day reset for Mr. Fernandez, please? Thank you. All right, we're going to come back on May 16th.
Yes, Your Honor.
And before that date, you need to have proof that you have employment, a second job, or either a full-time employment. Do you understand?
Yes, Your Honor.
All right, everyone wants their restitution back.
Yes.
And let me see, who else is here? Gabriel Gonzalez.
Yes, ma'am.
Hi, you're requesting permission to travel?
Yes, that was requested for this weekend, but I'm already gonna head back today. I just got permission to travel to El Paso.
Who gave you permission to travel?
Appeal.
No, see, it says here that you want to travel, and you're saying your probation officer gave you permission to travel.
Yes. Yes, the traveling, it was to travel outside country into Mexico. That didn't happen.
So you didn't go?
No, we just traveled to El Paso, Texas. That's all it is.
All right, because I can't have someone going out of country based upon your charges. You understand?
Yes, and it was explained to me, so that's why it didn't happen.
All right, thank you. You're excused then, unless there's anything else to address with him, Ms. Reyes?
No, ma'am.
All right, you're excused.
And Victor Fernandez can be too. He just needs to call his officer and let him know.
All right, Victor Fernandez, you can be excused. You need to speak with your officer.
Thank you, Your Honor.
Thank
I
you.
will. Bye-bye.
And
Bye-bye.
Judge Manuel Leos is in the courtroom.
All right, can I see Manuel Reyes, courtroom?
Leos.
Leos, please.
You can't hear?
Yeah, it's hard. I can hear barely. I mean, this one's dead, this one's given out. But I can hear you, I was hearing you back there.
All right, just give me a moment.
Can you hear that? Can you hear that? I'm gonna turn us deaf for a little bit. Yeah, I'm going up a little.
Good.
Okay, Your Honor, I'm ready.
Yes. So here's the thing, Mr. Leos, I see where you're requesting that your device be removed.
What device?
The in-home device, you're asking that that be removed?
Yes, ma'am.
All right, I understand your financial difficulties. I really do. But you're charged with driving while intoxicated. So did that driving while intoxicated happen before or after you were placed in the wheelchair?
I was in surgery. I just got out of the hospital when that happened. I still had my foot, but I didn't have none of my insole. It was gone. And right shortly after that, is when they amputated.
All right. So what has been amputated, Mr. Leos?
Ma'am?
What has been amputated?
What has been amputated?
Yes.
My right foot below the knee
All right. How did you get to court today?
with my son, he brought me.
Where's Mr. Leos' son?
Step up here. Yes, go ahead. Take your sunglasses and sunglasses off.
All right. Are you Mr. Leos' son?
So
How does he go to different appointments?
through me, sometimes I have a job and there's times I can't take him. I mean,
So when somebody else takes him, how does he get where he needs to go? Who else takes him?
it could be my brother, or sometimes he jumps on the bus.
All right. Rebecca, is there any other way to monitor him other than the in-home device?
The other device, like the Scram device, is more costly. We can just do more frequent using the call-in line for the drug test and be specific for alcohol. The officer was recommending hair follicle, which is costly, but that's covers every 6 months.
Mr. Leos,
ma'am.
with the UA hotline, that means that you would have to come in whenever they call you to come in. Is there going to be someone who's going to be able to bring you in?
I'm not sure. I mean,
Here's the thing, you have to be monitored.
yeah. Because as far as driving, I mean, my vision, I lost the vision on my right eye.
But here's the thing, Mr. Leos, you've been driving before. That's why we're here for a driving while intoxicated third or more. My question is, if we were to do the UA hotline, will you be able to abide by those conditions? Yes or no? That means when they call you to come in for a drug test, you need to come in for that drug test. They could call you this afternoon.
Yeah, I can do that.
All right, then they're saying that you're financially unable to pay for the in-home device. So I'm going to want from you an affidavit of non-driving. If it turns out that you're driving, you could end up going to jail and maybe going to prison. You understand?
Yes, ma'am. I don't even have no urge to drive because I can't see no more.
You know what? Here's the thing. People say that, but then the next thing you know, they're driving.
Yeah.
So let me explain something to you. The fact that you're in a wheelchair will not stop me from sending you to prison if there's a reason and if you should go to prison. Do you understand?
Yes, ma'am.
There are people at the prison who are in wheelchairs.
I was
So
just-
if you want the in-home device removed, then you need to provide me with an affidavit of non-driving, and then we will do the UA hotline. So Rebecca, the in-home device is not to be removed until he does an affidavit of non-driving. Then we will do the UA hotline. And I'm going to want field visits random 2 times per month. And if he ends up testing positive for alcohol at all, let me know.
Yes, ma'am.
All right, do you need to see him in a breakout room?
Yes, I will need to see him.
All right, to the courtroom. Could you go to breakout room number 1, please?
Yes, Judge.
Thank you.
Your Honor, I'm back.
Just one moment.
Yes, ma'am.
Ray Adams, who do you have?
I have Vernon Coleman, and I need to look at the PSI. If I could have, I'll put it in the chat, my email.
I just sent it right now.
Great. Okay. Can
right.
I be put in a breakout room with my client so I can discuss it with him?
All right, where is Vernon Coleman?
He's down on the thing right there. He's in jail.
All right, that doesn't help me, but let me try to find him.
That was no help at all.
All right, Vernon Coleman, I'm going to send you Jeremy Best. You left Mr. Newman in the breakout room by himself. All right, I'm going to send you to breakout room number 18, Ray. And Mr. Coleman, if you'll go to 18, please.
Excuse me, Judge, what breakout room did you send the courtroom?
Oh, the courtroom is going in now. Let me see.
Okay.
Let me find out which room they went to. All right. I'll send the courtroom to breakout room number 1 as soon as I find them on the Zoom screen.
Yeah,
Courtroom,
I couldn't find him.
yeah. Courtroom, could you go to breakout room number 1, please? All right, Stephen Redgate.
Yes, Your Honor.
Yes, what is happening with your client?
We've come to an agreement with the, excuse me, Your Honor, district attorney, subject, of course, to your approval of it, but we're ready to proceed.
All right, is
the
there
MTR.
paperwork that's involved? Okay, well, she needs to sign paperwork. Has that been done?
No, Your Honor, not yet.
All right, you need to let Ms.
I'm sorry.
Ferguson know what the agreement is, and she will send the paperwork. Mr. Redgate, if you can go, to room number 2, go back there, and I'll send your client to breakout room number 2 as well.
Thank you, Your Honor.
You're welcome. And everyone, just give me a moment. And Rebecca, I just sent the courtroom to number 1. And Ms. Ferguson, if you could go to breakout room number 2, please. All right, Bob Hicks, who do you have?
Ronnie Ray Lopez, Your Honor.
Criminal trial division or family violence?
It's a family violence case.
I'm going to send you to number 19.
Thank you.
You're welcome. Deborah Burke.
Good morning, Your Honor. May I please meet with the CLO to get a copy of the MTR and the probation officer's report on Manuel Galvan, and then I'll want to confer with the prosecutor.
Okay. Is it criminal trial division or family violence?
Criminal trial division.
All right, as soon as probation comes back into the main room, we'll get that document to you.
Thank you.
All right, You're welcome. Nathan Slimane.
Good morning, Your Honor. I did confer briefly with Ryan, and he conveyed a preliminary offer. I'm here with Mr. Peterson in the courtroom. We're going to review the discovery and whatnot today. I asked him to be here not just for that reason, but immediately before the weekend, I had approached Judge Angelini on the bench while he was here about waiving the GPS fees for Mr. Peterson, who was indigent. He set off the fees until today so that the court could issue an actual ruling in case the court had any questions for Mr. Peterson. He's on full house arrest, and his family is just not able to afford those GPS fees. So respectfully, we would ask the court in its power to waive them.
All right, has a motion been filed or no?
A motion has not been filed, Judge. I did talk to Marcus briefly. I didn't think there's any opposition to waiving the fees.
Oh, no, I mean, the waiving the fees, I'll waive that most definitely. But I will need a motion, and I see Mr. Peterson. I don't know why it's showing him in jail.
Yes, Your Honor. He's here next to me, Judge, in the courtroom.
All right, so the GPS fees will be waived.
Thank you, Your Honor.
And why is he on GPS?
I'm not exactly sure, Your Honor.
All right, just one moment.
I know he does have a interlock ordered also as a condition of bond, but I was unsure why there's a GPS.
All right, is there a criminal trial division prosecutor available? Mr. Smith, is there a reason you keep playing with your hair? Everyone can see your hair. Does it need a shampoo? Does it need conditioner? What is going on?
My head was itching.
All right, so here's the thing. You're in court. Could you please sit up straight? Am I asking too much of you? And stop playing with your hair. This is not a fashion shoot. All right, Mr. Slimane, I'm going to try to find out why your client is on GPS and whether he should be on GPS to begin with. Do you know of any criminal history that he has that's of concern? Has he not reported?
As far as I know, Your Honor, the only criminal history he has is of the same type of offense, driving while intoxicated.
Do you know if there are conditions in place for him not to leave his home? Is he on full GPS?
Full house arrest, Judge. Yes, Your Honor.
Do you know how many DWIs allegedly he has?
I don't know the exact number. I know that there's been one prior TDC trip.
All right, and
So he's
Mr.
indicted as a repeater.
All right, let me see. All right, the repeat offense is a DWI. So this is sort of like allegedly, this is sort of like the sixth. So now I see why they have him on GPS. I guess they don't want him to leave the home at all. But does he have ignition interlock on all the vehicles at the home?
I don't have any vehicles of my own.
All right, see, that's the problem. And Mr. Slimane, if you can find out for me, because I'm trying to figure out whether I want him on GPS or not. And of course, this is all allegedly. Allegedly, can you find out if the vehicle he was alleged to have been driving, is that vehicle, is his vehicle, or did he get it from someone else, allegedly? Because then I may be able to see why they have him on GPS. Because Mr. Peterson, I can't have someone who says they don't have a vehicle, but yet they mysteriously drive. And so I'm thinking they may have put you on GPS because they don't want you driving at all. And that your word that you're not driving is not enough. Okay?
Yeah, sure. Honor.
All right. So Mr. Slimane, if you can find out those answers for me, and maybe I'll keep him on GPS, maybe not, but I most definitely will waive the GPS fees.
Thank you, Your Honor. I appreciate that.
And is there anything else other than waiving of the GPS fees?
Not this morning, Judge, except possibly, I don't know exactly how this works. Mr. Peterson, one of the reasons why his family did come together to get him out, he does have a series of serious health problems. He was seeing a specialist, or more than one specialist, before going into the Bexar County Jail, and they wanted him to be able to resume those appointments. What his understanding from talking pretrial is that he cannot go to any doctor's appointments while he's on full house arrest. I don't know if that's exactly correct or not. I assume that if he provided information regarding an appointment, he could go, but otherwise we would ask the court at least to move it to partial, but I guess we can take that up when the court decides whether to even have him on GPS.
Well, for now, he'll still be on GPS, and you'll need to file a motion to remove the GPS, Mr. Slimane, so we can have a, so you can confer with the prosecutor with regards to that. And then
Okay.
I will allow him to attend all doctor's appointments, but Mr. Peterson, you need to give that information to pretrial services and let them know when your doctor's visits are. Of course, Mr. Slimane, if there's some kind of emergency doctor's visit, just let the court know. As you know, I don't sign pretrial violations without bringing attorneys in, unless there are always exceptions, unless there's maybe a new offense. But other than that, I always set those for hearing. So Ms. Ferguson, on Mr. Peterson, can we have a 30-day reset in the chat box, please? And so has the state tendered you an offer?
They did extend an offer this morning, Judge. So Mr. Peterson is here this morning. He wants to review discovery with me. We're going to do that, and we will contemplate the state's offer and decide if there's any other discovery we need to request. So we would ask for a reset to be able to do that.
All right.
This is the first setting.
All right, just give me a moment. Mr. Posada, you've been assigned to breakout room number 3. Please go to breakout room number 3, Jesus Posada. Thank you, Mr. Posada. All right, and then Ms. Ferguson, can I have a 30-day reset in the chat box, please? Just give me a moment. All right, it's going to be May 23rd.
Very good, Judge.
All right, you are excused. And to the clerk, could I have the B page on Henry Lee Peterson, please? All right, thank you.
Thank you, Your Honor. Have a good week.
You're welcome.
Thank you.
All right, Will Brooks.
Judge, on Matthew Luna, I was just going to let the court know we've got our plea paperwork completed, and it was with Lupe, who verified that it was done.
All right. Is there a prosecutor available to take this plea?
Do you need somebody for a plea, Judge?
Yes, please.
I'm here.
Thank you. Miguel Nahara, I'm going to send you to breakout room number 7.
Thank you, Judge.
Yes. And let me give you this. All right, the court is going to call 2021 CR 9686, State of Texas versus Matthew Luna. Can I have parties announced for the record for the state?
Michael Villarreal for the state.
For the defense?
Will Brooks for Matthew Luna, Judge.
And are you Mr. Luna?
Yes, ma'am.
We're proceeding by video due to the pandemic. Any objections from the state?
None from the state, Your Honor.
Any objections from the defense?
No, Judge.
Mr. Luna, I'm showing you what's entitled Defendant's Consent to Appear by Video Conference. Did you review that document with your attorney? Did you understand it? Did you electronically sign it?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily consented to appear by video. Next, I'm showing you what's entitled Application for Deferred Adjudication or Community Supervision. Did you review that document with your attorney? Did you understand it and did you sign it?
Yes, ma'am.
Mr. Brooks, I'm showing you what's entitled Discovery Acknowledgement. Have you received all the discovery in this case, and did you review it with your client?
Yes and yes, Judge.
Court will find that the state is in compliance with discovery. Mr. Luna, I'm showing you what's entitled True Bill of Indictment. Did you review that document with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
We do, Judge.
State, it appears that you are proceeding on the lesser included offense of assault, bodily injury, married, or cohabitation. Is that correct?
That's correct, Your Honor.
Any objections?
No objections, Your Honor.
Mr. Luna, I'm showing you what's entitled Court Admonishments and Defendant's Waivers and Affidavit of Admonitions. Did you review that document with your attorney? Did you understand it? And did you electronically sign it in all the appropriate places?
Yes, ma'am, I did.
All right, off the record for a moment. Ms. Reyes, Deborah Burke says that she needs a copy of the motion to revoke.
Yes, ma'am. I put in the chat that I needed her email to send that to her.
All right, Ms. Burke, if you'll place your email address to the CLO, please. We're back on the record. Mr. Luna, the state is proceeding on the lesser included offense of assault, bodily injury, married, or cohabitation as a Class A misdemeanor. The range of punishment is up to 1 year in the Bexar County Jail and up to a $4,000 fine. Did you understand?
Yes.
If you have a plea bargain agreement with the state, the court does not have to follow your plea bargain agreement. If for any reason the court does not follow your plea bargain agreement and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, I understand.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent. Did you understand?
Yes.
Did you understand by entering this plea bargain agreement, you were giving up those rights?
Understood.
Did you intend to give up those rights and enter into a plea bargain agreement in this case?
Yes.
Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty, not grant you community supervision, and sentence you up to 1 year in the Bexar County Jail? Did you understand?
Understood.
Counsel, has your client been able to provide you with any defenses to this offense?
Yes, he has, Judge.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
I do, Judge.
Mr. Luna, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, Your Honor.
Has anyone promised you anything other than the plea bargain agreement to get you to enter this plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes,
Are you a U.S. citizen?
I am.
Court will find the defendant has knowingly and voluntarily waived his right to jury trial. Showing you the plea bargain page, did you review that page with your attorney? Did you understand it?
Yes.
According to the plea bargain agreement, the state is proceeding on the lesser included offense of assault, bodily injury, married, cohabitating. There's a $1,000 fine. State recommends deferred adjudication. There's 2 years deferred adjudication is what they're requesting, but do you understand the court is in charge of the conditions? Do you understand?
Yes, ma'am.
There's the BIPP course, affirmative finding of family violence, no contact with Denise or ORR and her dog, mental health evaluation, and GPS for 90 days. Did you understand that to be the plea bargain agreement?
Yes.
Defense, is that the plea bargain agreement?
Yes, it is, Your Honor.
State, is that the plea bargain agreement?
Yes, Your Honor.
Next, I'm showing you the paragraph entitled Waiver Appeal Paragraph. Did you review that paragraph with your attorney? Did you understand it? Did you electronically sign it in both places?
Yes.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Understood.
Counsel, have there been any such motions?
We have motions on file, Judge, but no rulings.
Next, I'm showing you outside the plea bargain agreement, the state is requesting that your deferred adjudication be for a term of 2 years. There be a TAP evaluation and 120 hours community service restitution. Did you understand those are recommendations from the state and the court does not have to follow those recommendations?
Yes, ma'am.
Then to the lesser included offense of assault, bodily injury, married, cohabitating, how do you plead? Guilty, not guilty, or no contest?
Guilty.
State, any evidence to support the defendant's guilty plea?
Yes, Your Honor. At this time, state up for state's exhibit number 1 and its attachments.
Any objection?
We've reviewed states one, Judge, and attachments. We have no objection.
Mr. Luna, I'm showing you what's entitled waiver and consent to stipulation of testimony and stipulations. Did you review that document with your attorney? Did you understand it? Did you electronically sign it in all the appropriate places?
Yes.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call, the right to remain silent?
Yes.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Understood.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. The court will accept into evidence states exhibits 1 and attachments. And Mr. Luna, did you understand with an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition?
Yes.
Did you understand with an affirmative finding of family violence, you're not allowed to be designated as primary custodial parent?
Yes.
Knowing that, do you still wish to proceed with the plea?
Yes, ma'am.
All right, the court will accept into evidence states exhibits 1 and attachments and review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. However, the court will defer finding of guilt as you apply for deferred adjudication. Are you proceeding with sentencing?
Judge, we'll waive the PSI and proceed with sentencing today.
Anything you wish to say on behalf of your client?
Judge, if I may, if the court has any concerns about the bargain, I can tell you that since this incident, Mr. Luna has not done what a lot of my clients do, which is sit on their butt and feel sorry for themselves and let the circumstances get them down. Previous to the incident, he was employed in the fitness industry. He lost his job partially as a result of this, Judge. He has been in school, enrolled in a program to learn coding since the incident, and the court was kind enough to grant him partial release on his GPS to do that. He has also made what I would characterize as substantial efforts. He's been attending counseling since September 15th of last year, as well as a faith-based recovery program and church as well, Judge, to try and address some of the issues the court might see in the incident report.
What is he receiving counseling for?
Judge, for alcohol, Your Honor.
Okay.
And then also for anger, I think anger management is a portion of that, Judge. So he is seeing a therapist. He is, I will let the court know his financial circumstances have changed since I was retained to represent him. He doesn't have a job right now. He will once he finishes the coding program in June, Judge, but he's had to scale back with his therapy to, I think, once a month just for financial purposes, but he was seeing therapists twice a month up until this past month, Judge. We've given a pretty substantial mitigation packet in the forms of support letters on behalf of Mr. Luna. He was actually arrested on an at-large warrant in Harris County for this charge, so he spent several days in the Harris County jail. I can tell you he has no desire to ever go back or set foot in a jail. Discussing those things with him. But based on those things, Judge, we're asking the court to follow the bargain and grant his application for deferred adjudication, Your Honor.
All right, Mr. Luna, anything you wish to say?
Just to add on, the therapy has been 4 times a month every week up until last month because my finances no longer allow it. It has now been twice a month, every other week. The crash-related recovery program is integrity, whereas alcohol is not the closest alligator to my boat. It's an integrity issue that I've been pursuing to address and recover from.
All right. Do you have any children?
No, ma'am.
And what is her dog's name or dogs?
Zuko.
So there's just one?
There were two. I'm not sure the situation.
All right. So this is what the court will do. Brenda, my computer is asking would I like to restart it. I will snooze it. You're like, no. All right. I'm going to sentence you to 2 years deferred adjudication. There's a $1,000 fine that will be probated. 120 hours of community service restitution. 40 of those hours will be waived if you provide proof of the COVID vaccination. I'm not requiring to get anyone to get the COVID vaccination, but if you do, 40 of those hours will be waived. You're to continue with your therapy and counseling. And Rebecca, if his therapy and counseling is the equivalent of the BIPP course, then that can be substituted for the BIPP course. If not, then he needs to do the BIPP course. There's an affirmative finding of family violence. There's to be no contact with the niece or her pets. We'll do a MIC evaluation, but it seems like he's already doing counseling, Rebecca. But Mr. Luna, the MIC evaluation is just to see if you should be on a specialized caseload. There's going to be continued GPS, waive the fees. And Mr. Luna, there is a mysterious GPS device that is free. I'm trying to track that down. I think I may need to get an investigator or have Mr. Brooks do that as his mission, should he choose to accept it. Proof of employment within 30 days. There's to be no employment as a home health care provider with minors. There'll be regular reporting, regular UAs, field visits, 1 time per month. Rebecca, is there anything else that he needs?
No, ma'am.
Mr. Luna, is there anything else you need from the court in order to be successful?
I have questions about the job requirement.
Yes.
The program that I'm in is a 22-week program. I'm on the second half of the program. I think I have something like 8 weeks left, and I expect to have a job by August.
Are you supporting yourself?
The house that we had was sold, and the finances from that have gone to therapy, my lawyer. The program's very expensive, and I'm fortunate enough to have a family that will support me in this time.
I think, Judge, the program is actually 9 to 5 as well, Judge. It's an all-day schooling educational program.
Yes.
All right. Well, we will see if you can find a part-time job. Because how old are you?
I'm 30 years old.
Here's my thing, Mr. Luna. I know your family is supporting you, and it's nice to have a family that will do that for you, but you got to work. And I understand school. And for all the young children out there, it's nice to follow your dreams. But when your parent says, this is the age time you have to get your education, and then after that, we're moving on to the next child, then when you follow your dreams, you got to make sure you can financially support yourself and not depend on anybody else. Usually the 17-year-olds, the 18-year-olds, their parents send them off to college or trade school or wherever and say, we'll support you because you're still getting your life together. But at some point in time, you should have already done that. So I realize that your relatives are supporting you, but trust me, they would appreciate it if you would get a job. So I'm sure there's a part-time job you can find. So I usually require that people have full-time employment, but because you're doing school, you say from 9 to 5, we will have part-time employment. And if that's a job that requires you to have a license, you may want to find out, probably through your attorney, whether or not this will preclude you from getting that employment. I'm going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that document with your attorney? Did you understand it? And did you electronically sign it?
Yes.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes.
And because this is a affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition. Do you understand?
Understood.
All right, Mr. Luna, good luck to you. We can go off the record. Mr. Luna, you
Judge,
probably
one last
shouldn't be in a relationship. Yes, Mr. Brooks?
I'm sorry, I was going to make one last request in respect to sentencing, Judge, but I
Yes.
didn't interrupt the court. In respect to the GPS monitor, Judge, his grandmother is turning 80 on May 27th. He has not done any sort of event. He has been restricted to partial release for school and church, but we're requesting that he be permitted to attend that event. And also, Judge, if the court would consider it, based on the court's order for him to get a part-time job, would the court consider GPS tracking for him to ensure that he doesn't go near the complainant, but also be able to monitor him during those 90 days? Judge?
We'll see how he does. And then you can always come back and ask permission for that. Now, with regards to his birthday on May 27th, where is it going to take place?
It's June 4th. I'm gonna open my phone so I can look at the address.
I've got everything wrong this morning.
Yes, I was like,
Yeah.
did I hear that wrong? No, I mean, I don't need the address. Is it in San Antonio?
Yeah, it's
Is it?
in San Antonio.
He did tell me May 27th, so that one wasn't on me. Looks like he corrected it.
No, he said May 24th.
June 4th.
June 4th,
June.
Judge.
Okay, June 4th. Okay, everybody's changing dates, Brenda. My mind is a steel trap. He said June 24th, but okay, now it's June 4th. All right, now here's the next question. Does your grandmother want you at her birthday?
She does.
Have you asked that?
Yes, ma'am.
Okay, Brenda, who asked their grandmother, hey, do you want me at your birthday? That's like me asking my mom, Mom, do you want me at your birthday? No, Stephanie, I don't want you there. Okay. Michael Villarreal, do you have any objection to him going to his grandmother's birthday party that he's asked if she wants him there?
No, Your Honor.
All right, so what are the hours for this birthday celebration?
2 to 5.
All right.
Michael can come too, Judge, if he wants.
Okay.
I will be busy, I'm sure.
All right, so the defendant is allowed, what is your grandmother's name?
Rosemary.
Rosemary.
Bueno.
I'm sorry?
Bueno.
How do you spell the last name?
Bueno.
Oh, Rosemary Bueno. Well, tell her happy birthday for me. All right, you're allowed to attend her birthday. And you said, I'll give you from 1:30 p.m. to 6:30 p.m. on June 4th. All right, is there anything else before we officially go off the record?
Judge, we just have victim impact. Can we do that in a breakout room?
Yes. All right, Mr. Luna, here's the thing. You probably shouldn't be in a relationship until you get yourself together. You understand?
Understood.
So work on yourself before you get into another relationship.
As I have been, yes, ma'am.
All right, well, continue. All right, Mr. Luna, if you will go back to breakout room number 1, please. And Mr. Brooks, if you'll go to 1, please. And who is the person who is doing the victim impact?
Marina will be reading it, so I put Marina in there already, Judge.
All right, thank you. Well, Mr. Luna, if you'll go to breakout room number 1, please.
And Judge, I'll be in room 1, so when they're done, I'll do the paperwork.
Thank you. All right, attorneys, if you are ready, you need to show your video. Mr. Kalfas?
Yes, Your Honor.
Yes.
I conferred with Michelle Hayden, and she received some discovery this morning that I'm assuming she's going to forward to me, and we remain ready on it. I think that she says that, you know, there's still maybe some outstanding discovery that she's waiting on, but we're ready.
What, you want a jury trial?
Yes,
Now?
ma'am. Yes, ma'am.
Okay.
we just received these medical records. Literally, Marina let me know we had them this morning. So, I need to go through everything.
How long is that going to take?
I mean, if it's a murder case, I'm not going to be ready tomorrow.
No, I understand that, but he wants a speedy trial.
Okay. Well, we've got another murder set at the end of May. I mean, we could set it sometime in June.
All right. Ms. Ferguson? Just one moment. All right, we're going to come back on June 7th for jury trial.
Judge, we have one murder set May 31st and then one set June 14th. So I would just request it maybe set June 28th to have some time. I know those two are both older.
Judge, this is the same gentleman that had picked up a new assault case, and then his bond was revoked. He was remanded without bond. We had a lengthy bond hearing on it, and he was denied bond. And so we would request the earliest possible date.
And I did tell Mr. Kalfas, in light of the discovery that's been missing in this case, that I would agree to a bond in this case, but it's not one that we seem to mutually agree on.
It was a $500,000 bond, Your Honor, that she said she would agree to.
All right. Ms. Ferguson, just give me a moment. Everyone, just give me a moment. I'm going to go to breakout room number 2 and see what the issue is. It's taken a little bit longer than usual because we have someone who hasn't used Adobe Sign ever. So on Mr. Doze, we're going to come back, and we're going to come back on Thursday.
Okay.
And that's Thursday, the 28th. And we will work on the bond issue. And then also we will work on a jury trial date.
May I be excused today?
Yes, you may be excused. We'll see you back on the 28th, and Mr. Kalfas will give you a jury trial date at that time.
Thank you, Your Honor.
You're welcome. All right, Nathaniel Navy.
Good morning, Judge. I'm here on Ashley Castillo.
Yes.
This was a matter, and I sent you an email, Judge, along with, and sent it to Michael as well. I believe he already has a copy of this is a motion to amend a bond condition. This was set last week, and we still need to get it set for a trial date, Judge, but I brought this motion up in front of Judge Angelini, and he said that he would just leave it to your discretion.
Is she on the docket today?
She's not. I just requested that we be brought back just so we could take up this one motion to amend bond.
What is the cause number?
2021 CR 10501.
I'm sorry, 10.
10501.
All right, just give me a moment.
Okay.
And with regards to the motion to amend bond conditions, are you all in agreement or not?
We're not, Judge. The state is objecting to my request.
All right, and did you filed the motion, correct?
I don't think I e-filed it, Judge. I just, because court was in person last week, I delivered one to the court. So I haven't e-filed it, but I did send a copy via email.
Okay, let me see. Michael Villarreal, just give me a moment. He's in a breakout room and I'll take that up as soon as he's out. Albert Acevedo, I'll send you to breakout room number 4.
You did.
You're welcome. Sophia Martinez.
Yes, Judge. I did confer with Brittany. She's given us an offer that she'll complete tomorrow because we needed some additional information from there. So I just need some time to go through that with my client, Judge, but I believe we'll be able to work that out.
All right. How much time are you specifically asking for?
Well, Judge, I need time for that and to take care of some financial matters between him and I, so whatever the court could give us would be appreciated.
All right, let me look at the calendar. All right, I'll set you for May 31st.
Judge, can we go into June?
No, I only give month settings at the most, unless there's a specific reason why it should be set further than that. All right, if there's nothing else, you and your client are excused.
Thank you.
Good seeing you.
Oh, take care. Thank you.
All right, you're welcome. Bye-bye. Mr. Hernandez, you're excused. All right, Chase Butler.
Good morning, Judge. I've conferred with Ms. Hayden. We've got a protective order that we're going to present to the court for the CPS file, and I'll continue to go through discovery. So if we can just get a reset.
Where's your client?
He's in the courtroom today.
All right, to the courtroom. Could I see Mr. Raymond Alejandro, please?
Good morning, Your Honor.
Good morning. So on Mr. Alejandro, do you have all the discovery? Mr. Butler.
Judge, I have the discovery that's in the state's file as to whether or not it's all of the discovery. I haven't determined yet.
So has an offer been tendered?
No.
Is there a reason the state hasn't tendered you an offer?
I think it's just that we're so early in the case. It was recently indicted. And so we're early, but other than that, I don't know.
Well, I know that the prosecutors who are indicting these cases normally are not the prosecutors in this court. Me, as a former prosecutor, before I would indict a case, I would always have the offer prepared. But I understand the issues when other people are indicting cases and the prosecutors in the court are not. We'll recall this. Just give me a moment. Ms. Ferguson, I need a 30-day reset on Raymond Alejandro, please. All right, we're going to come back on May 23rd. At that time, the state will make an offer.
Thank you, Judge.
You're welcome. You and your client are excused. Mr. Alejandro, they're going to give you a reset form.
Thank you, Your Honor.
You're welcome. Albert Gutierrez.
Good morning again, Your Honor. Albert Gutierrez for Jesus Posada Mendez. I have conferred with the prosecutors on this matter, Judge. We received our first offer today. The first issue, Judge, my client is a Mexican national. He is here legally. I was wondering if the court would be willing to appoint an immigration lawyer for him to confer with on the offer. And there still is an issue on the DNA analysis that the state submitted that has not been submitted, but I'm just advising the court. I don't.
Wait, hasn't been submitted where?
To the Bexar County Forensic Science Center.
All right, who has the DNA?
Judge.
Yes.
So this case involves where there's clearly, based on the serology, male DNA. And so I reached out to the detective last month to have him do the defendant and a other male. And she said he was going to follow up. And then when I followed up with this morning, he said he has not gotten those buckles yet. And so they have not submitted to the lab. And I confirmed with the lab that nothing else has been submitted.
So who is actually the person? Is it the state and agents of the state who hasn't submitted it?
That's correct, Your Honor.
So when are they planning on submitting this?
Judge, when I talked to him this morning, he was currently at Child Safe attending a forensic interview, and he said that he would get back to the office and work on it. So I can follow up this afternoon with him to make sure that he does it immediately. But other than that, I don't have any much further detail.
All right, Ms. Ferguson, on Mr. Jesus Mendez, can I have a 2-week reset for DNA to be transferred to appropriate authorities? I come back on May 9th for that. And Ms. Ferguson, can you have an immigration attorney zoom in, please? And Mr. Gutierrez, is your client solely a Spanish speaker or does he need an interpreter?
He speaks English, Your Honor.
All right, thank you. All right, we're going to come back on May 9th, but if you could stay, Mr. Gutierrez, we're going to get an immigration attorney in here.
Okay, thank you, Your Honor.
You're welcome.
And Judge, on a different matter, can you I've assigned him there, Mr. McIntyre, go to room number 6.
Mr. McIntyre, please go to room number 6.
I'm sorry, room number 7.
Mr. McIntyre, please go to room number 7. Stanton McIntyre, go to room number 7. All right, and then the other matter we have, Mr. Villarreal, we have Mr. Navy on Ashley Castillo requesting a change in bond conditions.
Yes, Your Honor.
Are you ready to proceed on that matter?
Yes, Your Honor, I am.
All right, the court is calling 2021 CR 10501, State of Texas versus Ashley Castillo. Can I have parties announced for the record for the state,
Michael Villarreal for the state.
for the defense?
Nathaniel Navy, Your Honor.
And are you Miss Castillo?
Yes, ma'am.
We're proceeding by video due to the pandemic. Any objection from the state?
None from the state, Your Honor.
Any objection from the defense?
No, Your Honor.
Ms. Castillo, do you have any objections with us proceeding by video?
No, ma'am.
All right, the court is in receipt from the defense a motion to amend conditions of bond. State, have you had a chance to review that document and are you prepared to proceed?
Yes, Your Honor, we are.
All right, defense, it's your motion.
Yes, Your Honor, thank you. So, Judge, in this case, my client has been on a GPS device since November, when I believe that was when she was processed and posted bond. Initially, she was on GPS full house arrest. In December, the court did grant a motion to amend her bond conditions so that she could work. So currently, since December 3rd of 2021, she's been on partial house arrest. And even just partial house arrest, Judge, has been a severe restriction of her pretrial liberty. She does live by herself, so it has been difficult. If she was granted tracking, she would be able to do other things a little bit easier, Judge, like getting groceries, doing chores, meeting family, things like that, Judge. She is scheduled to move, I believe, at the end of this month. I know that she still technically should be able to do that as her conditions currently are, but I know that moving requires a lot of different trips and leaving the house, Judge. So not only that, but just because of the hardship that this has caused, and since she has been on a GPS device, Judge, she's, to my knowledge, had no violations whatsoever, whether she was on full house arrest at the beginning or on partial. She's totally amenable to having the tracking restriction be to the residence of the complaining witness or wherever locations the complaining witness frequents. So whatever locations that would keep her away from that person, she's totally fine with, Judge. Whatever address that needs to be. And so we would just request that you grant this bond condition amendment to tracking rather than partial house arrest.
All right, state.
We spoke to the complainant regarding this specific issue, and I can proffer to the court that she said when we asked about how she felt about this, she was concerned about her safety and it made her feel uncomfortable. At this point, she's allowed to work and she's allowed to provide herself a living. And so based on the complainant's feelings about this condition changing and the nature of this offense specifically, part of the indictment is her alleged to have gone near the residence of the complainant. We would object to any further changes of GPS.
All right, so on partial, the defendant is allowed to work, and you're saying, Mr. Maybe that is all she's allowed to do?
Yes, Judge. It's just partial for work, to my knowledge. I don't think that there's any other locations that she's allowed to do or allowed to go.
What days of the week is she working?
If you could ask her, Judge, I don't know exactly which days. I think it's Monday through Friday.
All right, Ms. Castillo, could you raise your right hand for me, please? Do you solemnly swear affirm the testimony you give will be the truth and nothing but the truth, so help you God?
I do.
All right, you can lower your hand. Could you state your name for the record, please?
Ashlyn Castillo.
All right, Mr. Navy, I'm going to ask your client questions as it relates to this motion, nothing about the facts of the case. Ms. Castillo, what hours are you working?
From 7 a.m. to 7 at night. Well, I don't get out till like almost 8. So.
All right, what days of the week?
Well, since I'm here, 12 hours. I work like 2 days and then I'm off 2, and then I work like 3 days and I'm off 2. But on my off days, since I don't have nothing to do, I always pick up and help out.
What are your off days?
Like I said, it varies, but I work throughout the week. I also work the weekend too. I pretty much work all the time though. Like I said, even on my off days, I'm always here and I always help out and pick up and stuff.
So Mr. Navy, I would give her a schedule where she can take one day that she's off to run her errands, but the issue is I don't know what day she's off.
It sounds like it's irregular days.
So since some days she's off on the weekends, I can tell you what I can do if she's not off on the weekend. Yes.
I'm sorry, I'm off every other weekend unless I pick up.
All right. So what I'll do, Mr. Navy, I'm not going to put her to tracking, but because you tell me she lives by herself, what I will do is on a day that she is off from work, I will give her a window where she can run whatever errands she needs to run since she lives by herself. State what hours would you be requesting? I know that you were requesting her not to do tracking, so I'm not going to give her tracking, but I am going to give her a window of time if she's off from work. And you'll have to let GPS know what day it is that you're off from work. You can't just say, well, the judge is giving me this block of time when I'm off. You have to let pretrial services know. This is the day I'm off, and I want to take this block of time to go do my errands. You understand?
Yes, ma'am.
So what block of time, Mr. Villarreal, would you agree to, or you would have no problem with for her to run her errands?
And just so I'm clear, this is for the time block for her to go run her errands.
Yes.
We wouldn't object at this point to a 9 to 5 for, one day a week.
All right. So, Mr. Navy, I'm going to give her 9 a.m. to 5 p.m. one day a week for her to run her errands. But you, Ms. Castillo, you have to let GPS know that I'm off today, whatever day it is, and say that you're taking your block of time from 9 to 5 to run your errands, but you are not to be around the complainant in this case. Do you understand?
Yes, ma'am, I understand.
So it would probably behoove you. I don't know if you were in a relationship or not, but I'm sure you probably know this person's habits and you probably know which area they do their grocery shopping in. You should probably not be in that area. You understand?
Yes, ma'am.
All right. So I'm going to alter and amend conditions. To allow you to run errands on an off day from 9 a.m. to 5 p.m. I already know with this order, Mr. Navy, pretrial services is going to want to call me. So if you could call them before they call me and just let them know my orders are when she has an off day, she will let them know what day it is and that she is going to be out and she's allowed to run whatever errand she wants to run from 9 a.m. to 5 p.m. on an off day.
And I assume she's to make sure that there's no issues gonna 24 hours notice.
Yes. And Ms. Castillo, household errands is not you going to concerts or whatever. You understand?
Yes, ma'am.
All right, where are we on discovery on this matter?
Judge, it's been completed. We finished that last week. There was some reports that we requested, and Mr. Villarreal got those to me last week, so it's been completed.
All right, has an offer been tendered?
Yes.
All right, Ms. Ferguson on Ashley Castillo, cause number 2021 CR 10501. Can I have a plea deadline date for 3 weeks, please? All right, we're going to come back on May 17th. That's your plea deadline date. At that point, you will need to let the court know if you're accepting the offer or not. If you choose not to accept that offer, then you will be set for jury trial. Is there anything else from either side?
No, Your Honor.
Any further to say?
All right, thank you, Ms. Castillo. You're excused.
Thank you, Judge.
Is there someone available for Rosa Madrano?
What is it?
It's a motion to revoke.
I'm here for Ms. Madrano, Your Honor.
All right, just 1 second. Let me find her file. All right, is there an agreement, Mr. Redgate?
Yes, Your Honor.
And what is the agreement?
The agreement is she is going to plead true, Your Honor, to failure to report. She is going to be adjudicated guilty, and she is going to receive the minimum sentence for the offense, as well as getting credit for all time served.
All right. All right, Michael, are you available?
Yes, Judge. Not my favorite, but I'll do it.
Thank you. I appreciate that. All right. Court is going to call 2013 CR 9191, State of Texas versus Rosa Maria Madrano. Can I have parties announced for the record for the state?
Michael Villarreal for the state.
For the defense?
Stephen Redgate here for the defense, Your Honor.
And are you Miss Rosa Maria Madrano?
Yes, Your Honor. Good morning.
Good morning. We're proceeding by video due to the pandemic. Any objection from the state?
None from the state.
Any objection from the defense?
No, Your Honor.
Ms. Madrano, I'm showing you what's entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision. Did you review that document with your attorney? Did you understand it?
Yes, ma'am.
Are you the same Rosa Maria Madrano who was placed on deferred adjudication in 2013 CR 9191 for the offense of possession of a controlled substance, penalty group 1, 4 grams to 200 grams? The motion to revoke states this is the offense is manufacturer in delivery. State, are you requesting to amend the motion?
Yes, ma'am.
Yes, Judge. The state would move to amend to change the offense to reflect the offense of possession with the intent to deliver a controlled substance.
Yeah. To reflect what's in the judgment?
Yes, Judge. Yeah.
Thank you. Any objections, Mr. Redgate? Mr. Redgate? Any
No,
objection?
Your Honor.
All right. Then
No, Your Honor.
The court will grant the state's motion without objection to amend the motion to enter adjudication of guilt and revoke community supervision. So the motion will be changed to the fact that the defendant is on probation for the offense of possession of a controlled substance, penalty group 1, 4 grams to 200 grams. Ms. Rosa Maria Madrano, are you the same Rosa Maria Madrano who was placed on deferred adjudication in 2013 CR 9191 for the offense of possession of a controlled substance, penalty group 1, 4 grams to 200 grams? on January 6, 2014 for a period of 4 years and extended for a total of 3 years. Is that you?
Yes, ma'am.
State, you're proceeding on violation of condition number 5. Ms. Madrano, violation of condition number 5 reads, in Bexar County, Texas, the defendant Rosa Maria Madrano did then and there fail to report to the supervision officer in person for the months of May 2029 and June 2029 in violation of condition number 5. How do you plead to that, true or not true?
True.
State, are you waiving the other violation?
Yes, Your Honor.
Any objections to the state's waiver?
No, Your Honor.
All right, Ms. Madrano, did you understand by pleading true to violation of condition number 5, the court could find it true, grant the motion, not grant you community supervision, and sentence you up to 20 years in prison and up to a $10,000 fine? Did you understand?
Yes, ma'am.
Knowing that, do you still wish to plead true to violation of condition number 5?
Yes, ma'am.
Court will find violation of condition number 5 true. Is there an agreement?
Yes, Your Honor. The agreement is to grant the state's motion, enter an adjudication of guilt, and assess punishment at 2 years confinement in the Texas Department of Criminal Justice Institutional Division.
Is that the agreement, Mr. Redgate?
Yes, Your Honor, but it's also to include credit for all time served.
All right, I'm required to give her that, Mr. Redgate. Ms. Rosa Madrano, is that
Yes,
the
ma'am.
agreement?
Yes, ma'am.
Are you asking the court to follow that agreement?
Yes, please.
Are you waiving your right to appeal?
No, ma'am. Oh, yes, ma'am. Sorry.
Okay, so are you waiving your right to appeal?
Like that means I don't want to appeal?
Yes.
Yes, ma'am.
All right, the court will find violation of condition number 5 true. The court will grant the motion, find you guilty, not grant you community supervision, and sentence you to 2 years in the prison, give you credit for any time served. Going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that document with your attorney? Did you understand it? And did you electronically sign it?
Yes, ma'am.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, ma'am.
All right. And because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. Do you understand?
I don't own guns anyways. Yes, ma'am.
All right, then good luck to you. We'll go off the record. Good luck to you. Have a great rest of your day. And if you have a drug or alcohol problem, you need to solve that. Otherwise, you're going to find yourself in and out of the prison system. Do you understand?
Yes, ma'am. Thank you so much.
All right, you're welcome. Good luck to you.
Thank you.
Thank you, Mr. Redgate. Albert Gutierrez. I'm going to send you to breakout room number 2. Mr. Mendez, I'm sending you to 2. Mr. Mendez, your immigration attorney is going to be Teresa Coles Davila. Mr. Redgate, you're excused. Thank you. All right, Daniel Rodriguez. I'm going to send you to breakout room number 4. Carl Alexander, I'm going to send you to number 5.
Thank you, Judge.
And who do I have in the courtroom? Kelly Piddle?
Yes, yes, Your Honor. And Marcus Sanders.
Yes.
Anton Hayek.
I see you, Mr. Hayek. I'm gonna get to you.
Judge, we have Christopher Rodriguez. He's on the docket for tomorrow. I believe Lupe brought you the file. This is one where defense had a motion to inspect the drugs filed, but due to me being out last week and having trouble getting hold of the detective, we haven't been able to get it accomplished. And so we're asking for a little bit of time to make that happen.
So when are we gonna make that happen?
I'm hoping within the next 2 weeks.
Does somebody want to call over there and see?
Yes, Judge, I tried last week. We're having trouble getting hold of the detective, and then I'm just trying to balance the possibility of being in trial. And so I don't want to say too short of a time and then not be able to make it happen.
Well, let's come back at 1:30 on this. I'm sorry, at 2 p.m. on this. And let's see where we are with regard to when the drugs are going to be expected.
Okay.
All right.
The only potential problem, Judge, is that we can set up a time, but with us being in trial, that may have to.
Oh, no problem. I'm just trying to figure out when the inspection is going to occur. So that's what I need to know.
Okay.
All right. Thank you.
Thank you.
Regina Tibbs.
Yes, Judge, I spoke with the DA. They have extended an offer to us. We wanted to reset it. This is our first trial setting.
All right. Do you have all the discovery?
Not yet. I got the discovery on one case, but not the other.
All right. Which case do you have the discovery on?
I have the discovery on case number 2945. I don't believe I have it on 2956.
All right, Ms. Ferguson, can I have a 30-day reset for Calvin Johnson, please? All right, we're going to come back on May 24th.
Okay, Judge, thank you.
You're welcome. You and your client are excused.
Thank you, Judge.
Thank you, Judge.
You're welcome.
Judge, when you get a chance, can I see you in a breakout room?
Yes, just give me a moment. All right, Alberto Acevedo.
Your Honor, I have Marla Garrison. I conferred with Marcus Sanders, and we're set for PSI today. There's been an unfortunate circumstance where my client was a victim over the weekend of a theft and assault, and that kind of goes to restitution that needed to be paid off by today. Judge, and he's in agreement with giving me a couple weeks so that I can request that police report and give her an opportunity to try to get that money.
This case has been going on since 2020.
Judge, just asked the court to give me a couple weeks to get this situated.
All right, Ms. Ferguson, can you recall Ms. Garrison on Thursday, please?
What time would that be, Your Honor?
Just 1 second. It will be at 9 o'clock. And Ms. Garrison, you need to appear in person in court. Courtroom is located at 300 De La Rosa. It's on the 4th floor, and we'll see you on April 28th at 9 a.m.
Yes, Your Honor.
Thank you, Judge. You have a good day.
Thank you.
Can I be excused, Your Honor?
Yes, you're excused.
Okay, thank you. Have a good day.
Thank you, you too. Miguel Bahara.
Yes, Judge. Good morning. I have conferred with Mr. Michael Villarreal on Stanton McIntyre. They did make a plea offer. I believe we're going to accept it. We were just going to ask for a short reset to take the plea, Judge, so we can get all the paperwork ready.
Oh, we can do the plea today.
Okay, Judge. I had some settings this afternoon. That's why I was hoping for a little time, Judge. It's going to be a reduction, so it shouldn't be a huge deal. But because of my settings this afternoon, I was just going to ask for a little more time, if possible.
Oh, they can get it done this morning, Miguel.
Okay, well, let me start texting, or excuse me, chatting Mr. Villarreal.
All right, thank you. Richard Garcia.
Judge, I'm here.
Yes.
So I conferred with Brittany, who's covering for Marcus, and she's extended the offer. I'm not sure how long, but Mr. Pope has rejected the offer again. And now he is no longer satisfied with my representation or advice and wants you to appoint another attorney.
All right, Mr. Pope, can you unmute for me, please?
Yes, ma'am.
Mr. Pope, let me explain some things to you. I've been a defense attorney, I've been a prosecutor. And here's the thing about that. As a defense attorney, your attorney receives an offer from the state. You can think the offer is ridiculous. You can say, I'll never accept that. That's completely up to you. But your attorney is obligated to present the offer to you. So once you've rejected it, then guess what? We're going to jury trial.
Judge Boyd, this isn't about the offer. This is about Mr. Garcia continually mocking me and making a joke of my defense here. And this case is 7 months old, and there's facts in this case that are not even coming to light that I'm repeatedly telling him. And all I keep getting told over and over, nobody cares about your rehabilitation.
Wait a minute, Mr. Pope. Here's the thing. Let me explain something to you about rehabilitation. Rehabilitation is the same word in legal terms as mitigation. Rehabilitation, unless somebody was at rehab when they were alleged to be committing the offenses, it really doesn't have anything to do with the facts of the case. You understand? Rehabilitation is another word for mitigation. It's sort of like if somebody were to say that someone is guilty of littering, and it's on video and somebody sees somebody littering, and you want to say, but you know what? That's what I did 2 years ago. Let me tell you what I've been doing now. What you've been doing now has absolutely nothing to do with the fact of were you littering or were you not littering. What you do now has to do towards punishment. Do you understand?
Yes, ma'am.
So you're going to jury trial. Ms. Ferguson, can I get a jury trial date for Mr. Pope?
The other thing that Mr. Pope does not recognize or want to believe is that he's indicted as habitual on 4 cases, Judge.
Mr. Pope, you're indicted as a habitual. You're indicted as a repeater on the felon in possession of a firearm. Do you understand that?
Yes, ma'am, I do. And the fact of the matter is, when I present my defense to Mr. Garcia, he laughs at me.
Mr. Pope, Mr. Pope, this is what we're going to do. All right. Ms. Ferguson, we're setting Mr. Pope for jury trial. And can you do Mr. Pope for jury trial at the end of May?
Your Honor, there's facts to this case that aren't even being brought out. And in 7 months, I am being thrown into jury trial without the facts even being brought out or investigated. That is my biggest problem here. I'm being rushed into a jury trial with a defense that isn't even trying to investigate the facts I'm telling him.
Judge, you did appoint a investigator, and she has been investigating and has been unable to corroborate any of the statements made by Mr. Pope. So
I understand what you're saying. I do. Your jury trial is going to be May 31st. I want you to understand what I'm saying. Your jury trial is May 31st. If you wanted another attorney, you will have to hire an attorney, and that attorney needs to come to court on May 31st, prepared to go to jury trial. So your jury trial is taking place on May 31st. And there will be 12 people in the jury box, and they will listen to the evidence and make a decision on whether you're guilty or not guilty. Is there anything else, Mr. Pope?
I mean, Your Honor, I literally just told Mr. Garcia a fact again today that I have been telling them since the beginning. And he
Mr.
is,
Pope, Mr. Pope,
that's
this is
fine.
a fourth trial setting. Your jury trial is going to be May 31st. If you would like to speak to Mr. Garcia again, I can send you both in a breakout room. You all can stay there as long as you wish. Do you understand?
Judge, I've heard his statements, what he has to say several times, and so I don't need to speak with him anymore today.
All right, Mr. Pope, we'll see you on May 31st. You'll be brought over dressed for trial. You will be brought over dressed for trial in whatever clothing you have at the jail. If there's different attire that you would like to be brought over dressed in, then you'll need to make arrangements with your attorney. Mr. Garcia, if there's an issue with the clothing exchange, the court will see what it can do to expedite that. Thank you. Number 14I, Mr. Pope.
Thank you, Judge.
You're welcome. Mr. Nahara?
Yes, Judge, I'm sorry. I was sending an email. I've been trying to get the chat to Michael, but I think Michael's in a breakout room. He keeps telling me he's not in this meeting.
All right, Mr. Schaefer? George Schaefer?
Okay, Judge, can you hear me now?
Yes, I can.
I'm waiting for Michelle Hayden.
All right, let me see where Miss Hayden is.
Judge, I'm right here.
All right, could you send Mr. Schaefer to a breakout room to confer?
Sure.
Ruben Flores, who do you have?
Judge, I have John Brown.
John who?
Brown.
Criminal Trial Division or Family Violence?
It is criminal trial judge, but I do not see him on the Zoom.
All right,
I've had no
Jess.
contact with him.
Just give us a moment, Mr. Flores. All right, to the courtroom. Are you ready on Miss Flowers?
Ben's ready, Your Honor.
All right, the court is calling 2018 CR 12139B, State of Texas versus Anidria Flowers. Can I have parties announced for the record for the state?
Ryan Grimmer for the state of Texas.
For the defense?
Anton Hayek from Ms. Flowers.
And are you Miss Flowers?
Yes, ma'am.
All right, the court was received in a motion filed by defense. Defense, are you withdrawing that motion?
Which motion are we talking about, Your Honor?
The motion where you asked that her plea be withdrawn.
Yes, Your Honor, we'll withdraw that motion.
All right, any objections to the withdrawal of defense's motion, state?
None from the state, Your Honor.
All right, according to the plea bargain agreement, punishment is to be assessed at a cap of 20 years. There's an affirmative finding of deadly weapon. Have both parties had a chance to review the PSI report?
Yes, Judge. Yes, Your Honor.
Any objections to the PSI report, state?
None.
Defense?
I have a couple of clarifications, objections, Your Honor. The first page of the bottom says guilt minimized, which I think is typical of the way she feels about this case, that it really wasn't her fault. On page 3, says relation to the victim as ex-boyfriend. I think they were intimate at the time. So it was a current boyfriend. They were living together.
All right. All right, defense, you're requesting that punishment be assessed at a cap of 20. Do you have any witnesses?
Yeah, we do. All right. Oh, Ms. Flowers.
No. State, do you have any witnesses?
I'm sorry.
Judge, yes, we do. State would call Cindy Roper.
All right, Cindy Roper. And just so everyone is clear, the court actually sat through this jury trial. The court has heard and the court remembers all of the testimony from the jury.
Judge, we don't have the witness set up yet, just for the camera.
All right, just give us a moment, then we'll take care of that.
So I'm trying to get here. I have it.
All right, everyone, just give us a moment. Are there any other attorneys who are ready?
Yes, Your Honor, Linda Corley.
Yes, Your Honor, Ray Adams.
Yes, Your Honor, the very best.
Okay, just
Yes,
one
Your
second.
Honor, Deborah Burke.
All right.
Do you want my stamp?
All right, Ms. Roper, can you raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God? I'm going to need you to speak up and speak into the microphone.
Yes.
All right. State.
Yes, Judge, thank you. Good morning, Ms. Roper. Could you introduce yourself to the judge, to Judge Boyd?
Yes, Judge Boyd, my name is Cindy Roper, and I am the mother of Isaiah Roper.
And Ms. Roper, as mentioned, as the judge mentioned, she's you testified before her before, correct?
Yes.
Ms. Roper, can you tell me who you are in relation to Isaiah Roper?
Yes, I am his mother.
And today I asked you, or you brought a photo of Isaiah, correct, for the judge to see a photo that we brought?
Yes.
May I approach, Your Honor?
Yes, you may approach.
All right. Ms. Roper, is that the photo? Ms. Roper, is that the photo that you brought to court today?
Yes, it is.
Okay. And for purposes of the record, I'm going to mark a duplicate of that photo as State's Exhibit number 1, which is a printed out copy of that photo. However, is that a photo? What is that a photo of? Yes, ma'am. Sorry.
My son, Isaiah Roper.
And is it a true and accurate photo of Isaiah that was taken of him?
Yes, it is.
State would offer State's Exhibit number 1, which is a photo of Isaiah Roper.
I've covered this on Mr. Bremer, no objection, Your Honor.
All right, State's Exhibit number 1 is admitted.
Ms. Roper, and I know this is at least slightly unusual, but if you look behind you on the screen, the judge is able to see from a camera angle directly in front of you. Can you show her a photo? Can you hold the State's Exhibit number 1 so she can see the photo of Isaiah?
All right, thank you. And just so everyone is aware, because I do realize that there were other prosecutors, I believe, trying this case. The court remembers all of the testimony and the court remembers all of the parties involved. So Ms. Roper, even though you're showing me that photo, I remember the photo from the jury trial.
Thank you, Judge Boyd.
You're welcome.
Ms. Roper, and like Judge said, there was a co-defendant in this case that she's very well aware, James Johnson, who you've already participated in the legal proceedings against him. The legal proceeding today is against a young lady named Mrs. Flowers, correct?
Yes.
Okay. in relation to Miss Flowers, and since you've last spoken in front of the judge, can you just give her a little bit of a reminder of who Isaiah was to you?
Of course, I've already mentioned he was my son. He was one of 4 of my children. I have 3 girls and 1 boy. He was our only son. He was the second to be born out of the 4. And he was just part of everything. He was our only son. And we no longer have him here. We no longer have anything to celebrate with him. All we have is memories because of the incident that happened.
Ms. Roper, I talked to you before this hearing and mentioned something that was especially hard for you that recently happened that reminded you a lot of Isaiah. Can you tell Judge about what that was?
Yes, sir. So every day is a struggle for us, and that will always be, and we get stronger every day. But there are certain moments and things that kind of pull back and we think on what would he have done if he was here. And the most recent was, of course, Easter. Every Easter, since he became old enough and he was too old to find Easter eggs, he would always hide. He would be responsible for hiding Easter eggs for the kids. And my oldest grandson, TJ, knew Isaiah was there for his birth and remembers him and talks about him often. On Easter, made the comment after they found the eggs was, remember when Uncle Isaiah was over there and he was dancing with us and the eggs and how many eggs we found? And he said, I miss him. And I miss that, but he's in heaven and he's watching us. And he can no longer enjoy those moments with his uncle. And it just made us all like, in that moment, be sad for a second, but we have to be strong for our children and our grandchildren and just say, yes, baby. And what I told him and what my husband told him was, yes, baby boy, he is watching down on you. And he's dancing up in heaven right now because you found so many eggs.
Ms. Roper, as we mentioned in front of the judge, you participated in the legal proceedings against Mr. Johnson, but today it's against Enidaria Flowers. And what's different about Ms. Flowers compared to Ms. Johnson in regards to your son's death?
I didn't know James Johnson. I had no ties to him. Anitra, who we call Anitra, I had ties to her. We brought her into our family, or we accepted her because my son loved her. We showed her love. We showed her respect. It was very, just to know that she would try to cause harm to my son and ultimately his death not only hurt us because we lost him, but to know that we loved this person and we accepted her into our family. And we trusted her. And that's what hurts also.
Ms. Roper, is there anything else you would like the judge to know in regards to the sentencing of Enidaria Flowers regarding the murder of your son?
I just want Judge Boyd to know that I trust in her to make those decisions and the right decisions. Because through this whole entire process, We have trusted in you to have justice for our son. He can no longer be here. So it has to be us that carries it on. And you have always, in the other trial and what's going on here, have always been respected by me and my family. And we trust in you that you will make the right decisions for the situation.
Thank you so much, Mr. Roper. I'll pass the witness, Your Honor.
Defense?
Mr. Roper, my name is Anton Hayek. I understand this is a trying situation for you. You have my condolences. I lost my only son too. There's never a good time for a parent to bury a child.
No, there isn't. Thank you.
Did you get a chance to review the report that was made with pre-sentencing of what you told the interviewer?
Yes.
Okay. And I see you talking about the family ties. Was Deidre and Isaiah were at your house many times?
Was it?
They were living together, I believe.
Yes.
Were you aware of any times that your son may have laid hands on Ms. Flowers?
No.
Were you aware of any arguments they had?
No.
Okay. And
Is there any tissue? I'm sorry. Is there any tissue? Sorry.
are you ready to take your hands?
Yes.
For some reason, we don't have tissue.
It's okay.
I haven't figured that out.
COVID's
Okay.
done a lot of things.
There's a big paragraph here. I was impressed how poignant it was that you wrote. It said sometimes you want her to get the maximum. Because your son's not here. And I can certainly understand that. And then you turn and say, why ruin her life too? I want her to have the minimum. I think that's very charitable of you. Because as you point out, and many people do, when you're doing these cases, nothing will bring your son back. And I don't mean to rub that in. I realize it's a little bit obvious, okay. And you know the minimum is 5 years and the maximum is 20 as to her case.
Yes, I do.
Thank you. I have no further questions. Thank you so very much.
I didn't know, was there a question in that or just a statement?
There
All right,
was a question.
any, just 1 second. Any questions, State?
Yeah. Thank you, Ms. Roper.
All right, thank you. State, call your next witness.
Judge, that's a state's only witness.
All right, defense, any witnesses?
Yes, Your Honor, I'd like to call Anidria Flowers.
All right, Ms. Flowers, if you can take the witness stand, please. Could you raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, you can lower your hand. State your name for the record.
Andrea Flowers.
All right, defense.
Okay, Your Honor, before I go too far, did you have receive a film I left on Friday for you? I saw a clip, and were you able to review that? Would have been a big white envelope.
All right, are you speaking to the court or are you speaking to the state?
To the court, Your Honor.
All right, so the envelope that you tendered to the court, is that the same video that was shown at the jury trial?
Having the slightest idea, I wasn't part of the jury trial.
Well, so if it's evidence from the jury trial, then the court has seen that at the jury trial.
I can't answer.
Did you, all right, let me ask you this. Did you allow the state to review what you tendered to the court?
No, ma'am, it came from the state.
No, Judge, I haven't seen it.
All right, so we're going to take a short break. Mr. Hayek, the court doesn't open or review any evidence tendered to me by the defense or when the state tenders evidence to me. I don't open it or review it. I don't open or review emails until it's offered and accepted. So with regard to the document that you've given me, I haven't opened it. So what I'll do is, I'm assuming, Mr. Hayek, that this is actually the video from the trial. I don't know if that's true or not because I haven't opened it. But what I'm going to do is I'm going to have the clerks give this to the state so you all can review it together and let me know if the state has any objections to this. All right, to the clerks.
The USD.
Could you give this to them in the courtroom, please? Thank you. State and the defense. All right, Mr. Schaefer, what is happening with your case?
I'm sorry, Judge.
Schaefer.
Yes, Judge. I've conferred with Ms. Hayden. We're still in discovery. We'd like to get this matter reset.
Who is your client?
Jesse Esparza.
All right, what discovery are we waiting on?
Judge, the state has indicated to me that there is no Coban videos. We're no longer waiting for any discovery.
All right, state, have you tendered an offer?
Yes, Your Honor.
They have.
All right, Ms. Ferguson, I need a 2-week reset on Mr. Esparza, please.
Judge, I won't be here. I've got a vacation letter on file. I won't be back until the 9th of May.
All right, Ms. Ferguson, can we set this the week of May 9th, please? All right, we're going to come back on May 12th. Mr. Esparza, that's your plea deadline date. The court will not accept any plea bargain agreements after that date. Do you understand, Mr. Esparza?
Yes, ma'am.
All right, you and your client are excused.
Thank you, ma'am.
You're welcome. Teresa Coles-Davila.
Hi, yes, good morning. Hi, Judge.
Hi. Hi. So did you get a chance to speak with your client?
I did get a chance to speak with his attorney, yes, and his client.
Okay. And so this is being reset for May 9th.
Okay.
And I know there may be issues still with regards to immigration, but we'll just see where we are at that time.
Okay, Judge, I'll try to get the Padilla letter over to him before May 9th.
All right. Thank you. Have a great rest of your day. Thanks for
Thank
popping in.
you. Thank you. You too. Thank you. Bye-bye.
Are we excused also, Your Honor?
Yes.
Okay. Thank you, Judge. Have a good
You're
one.
welcome. You too.
Thank you, Judge.
You're welcome. All right, and
Judge,
everyone, just give me a moment. I'm signing paperwork. My computer is working a little slow.
Judge, I was just gonna see if Norma got my chat for the deferred application on Mr. Stanton.
Okay. All right, I think she's working on that now. All right, Ruben Flores.
Yes, Judge.
Your client is Mr. Brown?
Yes.
All right, is there a Mr. Brown in the courtroom, Deputy Laura?
No, Judge.
And there has not been a Mr. John Brown. Is there a John Brown on the Zoom screen? All right, is there a prosecutor available?
Judge, I'm in the courtroom. I can do it.
All right, thank you. Court is calling 2022 CR 2974, State of Texas versus John Daniel Brown. Can I have parties announced for the record, please, for the state?
Ryan Grimmer for the state of Texas.
For the defense?
Ruben Flores.
All right, this case was set at 9 a.m. It is now 11:30 a.m. The defendant has not appeared on the Zoom. And Deputy Laura, Deputy Mejia, is there a John Daniel Brown in the courtroom?
No, Judge, he is not.
All right, defense, have you had any contact with your client?
I have not had any contact, Judge. I've tried to contact him with the information given to me in the appointment order and have had no luck.
All right, state?
Judge, state would make a motion to have his bond forfeited and ask for you to issue a warrant.
All right, that'll be granted. Mr. Flores, I'm going to remand your client without bond. But of course, if your client makes an appearance to the court by this week or next week, either in person or by Zoom, the court will reconsider.
Thank you, Judge. I'll reach out to him again.
All right, thank you. You're excused.
Thank you.
All right, Richard Garrett, who are you here for?
Good. There we go. Good morning, Your Honor. I'm here on Victor Magianes. It's an NTR with Mr. DeWalt as the defense attorney.
All right, what is happening with this case?
I think right now we're trying to determine whether Mr. Magianes has either logged on or appeared in court. I don't see him on the Zoom, and we're interested in whether he showed up or whether he's here.
All right, Deputy Laura, Deputy Mejia, is Mr. Magiano?
He's in the courtroom.
Magianes, he's in the courtroom.
Okay, great. Then I think Mr. DeWalt needs to confer with him.
All right, to the courtroom, could you let Mr. DeWalt confer with his client? Mr. DeWalt, do you happen to have your client's number? Are you able to confer with him by phone?
I would need his number. I do not have his number. That was the issue.
All right, to the courtroom, could you go to breakout room number 1 briefly so Mr. DeWalt can get his client's number?
Yes, Judge.
Thank you, Judge.
You're welcome.
Thank you, Your Honor.
You're welcome. Linda Corley?
Yes, Your Honor, I am here on Mr. Albert Alvarez. He is in custody. I have conferred. We did receive a plea offer on April the 6th. I conferred with Marcus. He is going to reach out one more time for me to the complainant witness. We've also filed a motion to set bond, Judge. His bond was revoked, and we're requesting to set a bond as well.
All right, Ms. Ferguson, Mr. Alvarez, can we recall this for next week? Next week, we will hear your motion, and we will also give the state a chance to speak with the complainant.
Okay, thank you, Judge.
All right, you're welcome.
Will I get that in email, or will she give
Oh,
that
no,
to
I'm
me?
gonna, she's gonna put it in the chat box to me. All right, we're gonna come back on May. Let me see, that's not the day. Ms. Ferguson, can I have a date for next week, please? All right, we're gonna come back on May 2nd.
Okay. May 2nd, Your Honor.
Yes. Norma
At 9 a.m.
Alvarez,
or
9 a.m. Ms. Ferguson, Alvarez 4P can go back.
Okay.
All right, Mr. Alvarez, we'll see you on May 2nd.
may I be excused, Your Honor?
Yes, thank you for your patience. All right, Tim Molina.
Hi, Judge. We have all the
Hello.
paperwork turned in on Albert Levine.
All right, has your client been sworn in?
I don't think so.
All right, I'm going to send you to a breakout room with your client so he can be sworn in. I'm going to send you to breakout room number 1.
Will it push him in there automatically? He's not real familiar with Zoom.
Well, I've sent him a request.
Okay.
Deborah
Thank you.
Burke, you're welcome.
Thank you, Your Honor. I've conferred with Joey Garcia on my client Manuel Galvan, and pending Mr. Galvan's urine test results today, we have an agreement.
All right.
So you want
has
to
he
bring
already
us
gone
back?
to take
No,
the
no,
test?
we're on Zoom, so he hasn't done anything yet. We're reporting to you first and wondering if you want to recall us tomorrow.
All right, we'll recall tomorrow. And just 1 second. Manuel Galvan, you need to appear in court tomorrow at 9 a.m.
Thank you, Your Honor.
You're welcome. All right, you're excused. We'll see you tomorrow at 9 a.m.
Thank you, Your Honor.
All
Manuel,
right, and
I'll
Mr.
call you.
Galvan, do you know who to go to get your drug test?
I'm sorry, ma'am?
Do you know where you need to go to get a drug test?
No, I don't, ma'am.
Well, just 1 moment. Are you Manuel Galvan?
Yes, ma'am.
What were the results of this drug test going to be?
The latest one was last week and they said it was watered down. So that's why we want to do another one because he didn't do anything to
All right,
make
Mr.
it
Galvan,
water.
what are the results of this drug test going to be for tomorrow?
I'm going to be good, ma'am.
All right. Ms. Reyes,
Yes, ma'am.
can you let Mr. Galvan know where he needs to go to do a drug test?
Yes, I'll put him in a breakout room, Judge.
All right, thank you.
Thank you, Your Honor. May I be excused?
You're welcome. Mr. Galvan, you need to appear tomorrow in courtroom in person at 9 a.m. Do you understand?
Yes, ma'am. Thank you.
Thank you.
Thank you.
And sir, I sent you to breakout room 2.
Jeremy Best.
Good morning, Judge. I have 2 motions to withdraw on file in this. I have Carletta Garcia. I'm not sure if she's in the courtroom. She's out on bond. I've tried to get in touch with her. I have not had contact with her. And then I have Mr. Newman, who's also here. I did try to get an offer from the state to possibly work everything out today, but Mr. Newman did not want the offer. And so I'm just asking that my motion to withdraw be granted. They're both court appointed, Your Honor.
All right, why are you withdrawing?
I moved to Corpus Christi, Your Honor. So my entire practice has moved down here. So I'm no longer local counsel.
All right, Mr. Newman, because this case is new, I'm going to grant his withdrawal. Do you have any objections to his withdrawal, Mr. Newman?
No, all I was trying to get was a
Mr. Newman,
yes,
stop. I just want you to listen to my question and answer my question. Your attorney who was appointed to represent you no longer resides in Bexar County. He resides in Corpus Christi. He wants to withdraw from your case because, as you can understand, driving from Corpus Christi to San Antonio on a daily basis or weekly basis is a lie. He wants to withdraw from your case. Do you have any objections to him withdrawing? That's either yes or no.
No.
All right, so you're withdrawing from his case. Ms. Ferguson, I need a court-appointed attorney for Mr. Newman, please. All right, Mr. Newman, we're going to get you an attorney. All right, who's your other client, Mr. Best?
Her name is Carlota Garcia. I can bring up a cause number if you'd like.
Is that set for today?
I believe so, Judge. And I wasn't sure if she's in the courtroom. I've sent her a letter and I've called the number that we got with the appointment, but I have not been able to have contact with her. So I'm not sure if she's there in the courtroom today.
Oh, it hasn't been indicted. Your motion to withdraw will be granted.
All right. Thank you, Judge. May I be
You're
excused?
welcome.
You'll only
Yes,
take
you're
5 minutes.
excused.
Thank you.
Andres Campion?
Yes, Your Honor.
Yes.
On Paul Ramirez, we did not realize that this was set for today until yesterday late in the evening, and so we've been trying to get a hold of Mr. Ramirez. It is an MTR where he has failed to appear. We do have an agreement with the state, but we do need to get Mr. Ramirez to be before the court before obviously we can resolve that.
All right, we'll see you back at 2 p.m.
Okay, I'll be back on and I'll keep continuing to try and contact him.
All right, thank you.
Thank
Daniel
you.
Rodriguez.
Yes, Your Honor, I have 2 motions to substitute on file, and I believe that's why you sent me today.
What is your client's?
I forwarded them to Norma, and I asked that she forward them to you.
We have a Montalvo.
Montalvo and a Borrego.
All right, let me see, where is Mr. Montalvo?
He's present on Zoom.
Mr. Montalvo? Mr. Montalvo?
Yes, ma'am.
All right, Mr. Montalvo, it appears that your Zoom isn't working. So from here on out, if your Zoom is not working, then you cannot be on Zoom. Do you understand? Mr. Montalvo?
Yes, ma'am.
All right, Mr. Rodriguez is substituting in every case because Mr. Campion no longer works with law offices of Allen Brown. Do you have any objections?
Can you hear me?
Yes, do you have any objections?
No, ma'am.
All right, Ms. Ferguson. On Mr. Montalvo, can I have a 2-week reset for a plea deadline date, please? All right, May 16th is going to be your plea deadline date, Mr. Montalvo. After that, the court will not accept any plea bargain agreements. Do you understand?
Yes, ma'am.
All right, and if your Wi-Fi or something is not working, you're gonna have to start appearing in court.
I will give him a call, Your Honor.
All right, and where is Adrian Borrego?
I don't see him on the Zoom. Adrian, you're here, please answer up. Let me, he might be in person.
All right, Timothy, Tim Molina. You have Albert Levine.
Yeah, we just got sworn to the paperwork.
All right, who's the prosecutor on this?
Michelle
Hayden.
All right, the court is calling 2019 CR 5167, State of Texas versus Albert Levine or Levine. Can I have parties announced for the record for the state?
Michelle Hayden for the state.
For the defense?
Tim Molina for Mr. Levine.
And are you Mr. Levine? You need to unmute. Are you Mr. Levine?
Yes, Your Honor.
We're proceeding by video due to the pandemic. Any objections from the state?
No, Your Honor.
Any objections from the defense?
No, Your Honor.
Mr. Levine, I'm showing you what's entitled Defendant's Consent to Appear by Video. Did you review that document with your attorney? Did you understand it? Did you electronically sign it?
Yes, Your Honor.
Court will find that the state is in compliance. The court will find that defendant has knowingly and voluntarily consented to appear by video. Next, I'm showing you what's entitled Application for Deferred Adjudication or Community Supervision. Did you review that document with your attorney? Did you understand it and did you sign it?
Yes, Your Honor.
Counsel, I'm showing you the discovery acknowledgement. Have you received all the discovery in this case and did you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Levine, I'm showing you what's entitled True Bill of Indictment. Did you review that document with your attorney? Did you understand it?
Yes, Your Honor.
Counsel, do you waive the reading of the indictment?
We do.
State, are you proceeding on the indictment as presented?
I am.
Mr. Levine, showing you what's entitled Court Admonishments. Did you review that document with your attorney? Did you understand it? Did you electronically sign it in all the appropriate places?
Yes, Your Honor.
Did you understand you're charged with injury to a child as a state jail felony? The range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. Did you understand?
Yes, Your Honor.
If you have a plea bargain agreement with the state, the court does not have to follow your plea bargain agreement. If for any reason the court does not follow your plea bargain agreement and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, Your Honor.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call and the right to remain silent?
Yes, Your Honor.
Did you understand by entering this plea bargain agreement, you were giving up those rights?
Yes, Your Honor.
And did you intend to give up those rights and enter into a plea bargain agreement in this case?
Yes, Your Honor.
Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 2 years in the state jail facility and up to a $10,000 fine? Did you understand?
Yes, Your Honor.
Counsel, has your client been able to provide you with any defenses to this offense?
He has assisted me in his defense, Your Honor. Yes.
Do you believe he has a rational as well as a factual understanding of the charges against him?
He does.
Do you believe he's currently competent and was legally sane at the time of the offense?
I do.
Mr. Levine, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, Your Honor.
Has anyone promised you anything other than the plea bargain agreement to get you to enter this plea?
No, Your Honor.
Are you satisfied with the way you've been represented?
Yes, Your Honor.
Are you a U.S. citizen?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Showing you the plea bargain page. Did you review that page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea bargain agreement, there's to be a $1,000 fine with $500 of it probated. State recommends deferred adjudication. There's to be no harmful or injurious contact with Madeline, Cruz, Danielle Cortez, the BIPP course, TAP evaluation, plus following all recommendations, parenting classes, 120 hours community service restitution, and there's an affirmative finding of family violence. Did you understand that the court is in charge of conditions of probation?
Yes, Your Honor.
Did you understand with an affirmative finding of family violence, you're not allowed to be designated as a primary custodial parent?
Yes, Your Honor.
Did you understand with an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition?
Yes, Your Honor.
Did you understand that to be the entirety of your plea bargain agreement?
Yes, Your Honor.
Defense, is that the plea bargain agreement?
Yes, Your Honor.
State, is that the plea bargain agreement?
Yes, Your Honor.
Next, I'm showing you the paragraph entitled Waiver of Appeal paragraph. Did you review that paragraph with your attorney? Did you understand it and did you sign it in both places?
Yes, Your Honor.
Did you understand by signing, just one moment, off the record? Eric DeWalt, I'm sending you to breakout room number 2. To the courtroom, could you go to breakout room number 2 for paperwork? We're back on the record.
Judge.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, Your Honor.
Counsel, have there been any such motions?
No, Your Honor.
Next, I'm showing you outside the plea bargain agreement. The state is requesting that your deferred adjudication be for a term of 5 years. Did you understand those are recommendations from the state and the court does not have to follow those recommendations?
Yes, Your Honor.
Then to the offense is charged in the indictment, how do you plead? Guilty, not guilty, or no contest?
I'm guilty.
State any evidence to support the defendant's plea.
State offers State's Exhibit 1, its attachments into evidence.
Any objections?
No objection.
Mr. Levine, I'm showing you what's entitled waiver and consent to stipulation of testimony and stipulations. Did you review that document with your attorney? Did you understand it? Did you electronically sign it in all the appropriate places?
Yes, Your Honor.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call and the right to remain silent?
Yes, Your Honor.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, Your Honor.
Court will find that the defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence State's Exhibits 1 and attachments and review the same.
Yes, Your Honor.
All right, after reviewing State's Exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. However, the court will defer finding of guilt as you've applied for deferred adjudication. Are we proceeding with sentencing?
We would waive the PSI, Judge.
Anything you wish to say on behalf of your client?
Only that this did happen back in 2018, and he has kept himself out of trouble. He is residing currently in a program through Haven for Hope at One Haven, or I think the apartment complex overseen by them with his family. And so the state was nice enough to agree to probate half the fine as to see if the court could consider any kind of accommodation possible to help him succeed, not worrying so much on the financial end and focusing more on reporting in the classes. And aside from that, we would just ask the court to follow the plea bargain.
All right, Mr. Levine, is CPS involved?
No, ma'am.
Judge, I asked them earlier, they were involved, but it was closed.
All right, did you do any classes for them to close this case, Mr. Levine?
I attended 2 of them, 2 parenting classes, and then I never attended the rest.
So you didn't finish parenting classes?
No, ma'am.
So basically what ended up happening is the mother of the child, is she with the mother?
Yes.
So what happened is the mother of the child stepped up to do whatever classes that were required of her, and you did not. So the
Yes,
case
ma'am.
was closed not due to your actions, it was closed due to the mother's action or the fact that they considered that the danger was alleviated by you not being around.
Yes,
So
Your
when's
Honor.
the last time you saw your child?
Maybe like 2 years ago, 3.
All right. So why are we doing no harmful or injurious contact? The child doesn't even know him anymore.
Judge, a lot of the notes on this case are from a long time ago. So at that point in time, he was involved.
All right. Are you employed?
No, ma'am, not at the moment. I'm Haven for Hope is helping me get my ID and social because I have my birth certificate.
All right. And is this the only child you have?
Yeah, I have one other child with the same girl, but I haven't seen her.
So this isn't the only child you have. You have, how many children do you have in this world?
2.
All right. This is what the court is going to do. $1,000 fine, probated, 5 years deferred adjudication, the BIPP course, affirmative finding of family violence, parenting classes. There's to be no contact with Madeline Cruz and Danielle Cortez. I just have a question, Mr. Levine. How is it that you're saying that I'm assuming one of these persons, Daniela Cortez, is your child, is that correct?
No, that's my baby mama.
Okay, Madeline Cruz is your child?
Yes, ma'am.
Okay, and can we say the mother of my child? Why is it that Madeline Cruz's last name is Cruz, Danielle's last name is Cortez and yours is Levine.
I have, that's the name she picked for her.
What, people just going around giving people last names that are not even related to anyone?
That's her mom's last name.
All right, well, that is not for me to understand. That's something for your attorney to understand why on a child's birth certificate, it doesn't have the mother of the child's maiden name. It doesn't have your last name, but it has the grandmother's last name. All right, so there's to be no contact with Madeline Cruz or Danielle Cortez, no unsupervised contact with minors. Mr. Levine, as soon as you do some parenting classes, of course, the court will reconsider the no contact order, but for now, your anger issues need to be alleviated, or you need to know how to control them, because little children don't have a lot of impulse control. And sometimes people tell me they will get on your nerves. And when they do, you have to know how to handle that and not handle that in anger. You understand?
Yes, ma'am.
All right, so there's to be no unsupervised contact with minors. Proof of employment within 45 days. There's to be no employment as a home health care provider or with minors. CPS compliance, if any. 120 hours of community service restitution. 40 of those hours will be waived if you provide proof of the COVID vaccination. I'm not requiring you to get the COVID vaccination, but if you do, 40 of those hours will be waived. You must complete parenting classes, and once you complete parenting classes, the remainder of your community service hours will be waived. There's to be regular reporting by Zoom or in person. Field visits, 1 time per month. If you're drug tested today, what are the results going to be, Mr. Levine?
I should be able to pass it. I've been at Haven for 2 weeks, so
When's the last time you used?
maybe like 3 months ago.
All right, we'll do regular UAs. Rebecca, is there anything else that he needs?
No, ma'am.
Mr. Levine, is there anything else that you need from the court?
No, ma'am.
All right, Mr. Levine, did you sign a document entitled Trial Court Certification of Defendant's Rights to Appeal? And did you understand it and review it with your attorney?
Yes, Your Honor.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, Your Honor.
And because there's an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition. Do you understand?
Yes, Your Honor.
All right, that will close the docket. Mr. Levine or Levine, good luck to you. Get a control of your anger
Yes, ma'am.
and do whatever DNA testing you wish to do.
Yes, ma'am.
Judge, does Mr. Levine stay and go into a breakout room with probation?
Yes.
What is his next step?
I'm going to send him to breakout room number 3, and probation will go over conditions.
Okay, thank you.
All right, to the courtroom. Did you have a chance to review the document that Mr. wanted me to view?
Yes, Judge. I did, Judge. It was a ring video. I don't know if that, I assume it's probably the same video you saw in the trial, but it is a ring video. I just didn't know what video it was, Judge. It is a ring video from our evidence.
Oh, Mr. Hayek, the ring video was produced at trial.
I'm sorry. I didn't mean to talk over you, Jeff.
No, that's no problem. We're not on the record. Mr. Hayek, the ring video was introduced at trial, but if there's no objection, I will review it again as well.
Thank you, Your Honor, and I'd like to reintroduce it again.
All right, we're going to go back on the record. Could the witness take the witness stand?
She's on the witness stand.
All right, thank you. All right, we are back on the record in 2018 CR 12139B, State of Texas versus Ms. Flowers. The defense wanted to offer into evidence defense exhibit number 1, which is a ring video. Any objection from the state?
None from the state, Your Honor.
All right, defense exhibit 1 is admitted. Defense, it's your witness.
Thank you. Anidria, how old are you now?
I'm 26.
Okay, so you were roughly 22 back in 2018?
Correct.
Okay. And at that time, before you got arrested for this offense, were you working?
Yes, I was.
And how were you working?
I was working at my uncle's cell phone company.
And were you going to school?
I had just started school for my business management degree.
Is that a type of college?
No, I was going to San Antonio College.
Okay. And were you living at home or were you independent now?
I have my own apartment.
Did you share that apartment with anybody?
Yes, I did.
With who?
I shared it with Isaiah Roper.
And about how long did y'all live together?
It was almost a year.
And was it always happy or was there any disturbances, assaults?
No relationship is perfect. We had our ups and downs.
Did he ever put his hands on you? You talked to me about laying hands.
A couple of times pushing and shoving, but
But nothing like the night in question?
correct.
Okay. And what makes that night so, I hate to say special, but so dangerous?
That I'm not quite sure.
Because the event actually starts a long time before we see that ring video.
Correct.
Is it not? And I'm not going to go over all the evidence. Judge knows it. Did y'all split bills when you were living together?
Occasionally, yes, if he could come up with his part, or when he couldn't, I wouldn't ask him because came along, I had my bills taken care of.
Just one moment off the record. Mr. McIntyre, I need you to go to breakout room number 1. All right, you may continue, Mr. Hyatt.
Thank you, Your Honor.
Mr. Hyatt, any
I'm
questions?
here, Judge. I'm just looking because I've asked some of the same questions already. Do you recall saying shoot him to Mr. Johnson?
No, I do not.
And you were on the ground at that time if you had.
Correct.
And Isaiah could have run off and not been shot. Is that possible or probable?
I assume so, yes.
So are you sorry that Isaiah is dead?
Yes, so to the family, I don't know if I'm allowed to speak to him or not, but I would like to say to Ms. Cindy and Mr. Lester, I do offer my condolences and I am very sorry that the situation transpired the way it did. If I could go back and change anything, I would. I'm sorry that your son is no longer with you. As you know, he meant a lot to me as well. I too lost my little brother last year, the year before last. So I do know what it feels like to lose someone. I only lost my little brother, but for you to lose a son, I can imagine is way worse because I'm still grieving for my little brother. So again, I'm very sorry for your loss.
And are you asking the judge to be merciful and maybe give you less than the maximum of this plea bargain range?
Yes, I am. I should have just changed the locks and not worried about the keys that night. I did not went over there trying to get my keys back. Everybody would be going about their day today. So I just wanted my keys back. I was young. I wasn't thinking. So again, I apologize to the family. But I would like to say that even if the judge does give me the minimum, I will be paying for this situation for the rest of my life because I won't be able to get a job anymore due to the nature of the charge. I now have a son who's going to be 2 in a couple of weeks, and going to PTA meetings and stuff like that for his school and stuff would be raise red flags to people. Anytime people try to order flowers for their family and they Google that, I'm the first thing that pops up. So I will be paying for this for the rest of my life. So again, I am very apologetic.
Ask the witness.
State.
Yes, Judge. Ms. Flowers, why did you bring a knife over to Isaiah's house that night?
As you can see, sir, I am very small. I am always small. I've always been small my whole life. It was a pocket knife, which I always carried on me. During my previous relationships, I have had people that put their hands on me, so I always carry a knife.
That knife had to be wrestled away from you after you pulled it out when you got to Isaiah's house, correct?
Correct.
Okay. Did you know that Mr. Johnson had a gun when you went over there?
No, I did not.
You didn't know he had a gun?
No, because, I mean, like I said, when people get in my car, the first thing does not, hey, do you have a gun? I mean, I don't go around questioning people, but.
Okay. So you were going over there to Isaiah's house, who was y'all were in a relationship or ending a relationship or whatever it has you. You asked Mr. Johnson, who doesn't know Isaiah, to come, and you didn't know whether he had a gun or not.
Correct.
And he brought a gun just because he wanted to bring a gun?
I mean, I'm assuming so.
I object to speculation on what Mr. Johnson's thinking.
Sustained.
But you claim you didn't know he had a gun?
Correct.
What was his purpose in coming over there with you then?
For me, it was just moral support. He just rode with me because I asked. Before me asking him, I called my brothers and stuff and asked them. One of my brothers lives in Austin, so he couldn't come. My younger brother, who's now deceased, he just had a lot going on. And my other brother, he just didn't want to come because it's kind of like, you know, you fight with your boyfriend or girlfriend today, tomorrow y'all got together, but I want to get involved. So for me, it was just support, just have someone there.
Okay. You said at the beginning, you said you're sorry to Lester and Miss Roper, correct?
Correct.
You know, Lester says that he heard you yell, shoot him, whenever Isaiah was shot. Are you saying that he's lying when he says that?
Yes, sir, I am.
Okay, you never said that.
No, sir, I did not.
Okay. You mentioned that you lost your, or I'm sorry, you mentioned that I think you said Isaiah meant a lot to you also, correct?
Correct.
When he was shot right in front of you by a gun that you say you didn't know was there, did you run and go help this person who meant a lot to you?
No, I did not. Reason being, I've never been around guns before, so I mean, I didn't know that when someone gets shot, they take off running full speed. Also, I did not know that he was shot.
Okay, what did you think had happened? If you didn't know he was shot, then.
I mean, I heard the gun go off, but I thought it missed him.
Okay, so you did know he was shot at, you just didn't think he was shot.
No, I didn't know he was shot.
So this person who meant a lot to you, you didn't stay with him there that night he was shot.
Correct.
Okay. You mentioned that this is going to be really hard for you as you go on with your life. Do you think it's going to be more or less hard than Isaiah's family?
Like I said earlier, I lost my little brother year before last suicide, and he was just my brother. So for them to lose a child, I can only imagine it's going to be way worse.
You mentioned it's going to be hard for you to get a job, right?
Correct.
Is Isaiah ever going to have a job?
No.
You mentioned your child. It may complicate relations with your child. Is Isaiah ever going to get to have a relationship with a child or get to have a child?
No.
Okay. You mentioned that you wish that certain things would have changed that night, but you also say that he was grabbing you and that's why this occurred, even though you didn't know about the gun. What would you have changed that night if you could go back?
What I would have changed that night is everyone out there just witnessing what was going on, because I believe, so when I figured out the situation was getting a little too out of hand and it was time to go, I started walking away. These individuals followed behind me.
When the situation got out of hand, was that before or after you had pulled out a knife?
That was afterwards.
Okay. So the situation got out of hand after you, Anisia Flowers, pulled out a knife when you showed up at their house?
Correct. And they all ran outside and bombarded me.
Ms. Flowers, you mentioned that previously Isaiah had put his hands on you. Did you make any police reports whenever that happened?
No.
Okay, so it's just your word right now on the sentencing on your murder case that happened.
Correct.
I'll pass the witness, Your Honor.
That knife, Ms. Flowers, wasn't it about 3-inch long blade? It was
Yeah,
a pocket
was-
knife, right?
Yes, it was pretty small.
Can you give us an idea of how long you think the blade was?
It was really used for mail opening.
And you didn't open any mails that night, did you?
You know,
In fact, didn't you threaten Isaiah's dad?
I don't remember, but according to the paper that I read, almost 20 minutes ago.
No further questions. Thank
All right, any further questions?
No, Judge.
All right, thank you. The witness can step down. Do you have any further witnesses, Mr. Hyatt?
One more, Your Honor.
All right, just give me a moment. Mr. Nahara?
Yes, Your Honor.
Brennan, I'm going to take up Mr. Nahara's case since he has to, who's the prosecutor?
Michael Villarreal, Your Honor.
All right, the court is calling 2022 CR 2949, State of Texas versus Stanton Charles McIntyre. Can I have parties announced for the record for the state,
Michael Villarreal for the state.
for the defense?
Miguel Nájera for the defense.
And are you Mr. McIntyre?
Yes, ma'am.
We're proceeding by video due to the pandemic. Any objection from the state?
And from the state.
Any objection from the defense?
No, Your Honor.
Mr. McIntyre, I'm showing you what's entitled defendant's consent to appear by video. Did you review that document with your attorney? Did you understand it? And did you electronically sign it?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily consented to appear by video. Next, I'm showing you what's entitled application for deferred adjudication. Did you review that document with your attorney? Did you understand it? And did you sign it?
Yes, ma'am.
All right. Counsel, I'm showing you the discovery acknowledgement. Have you received all the discovery in this case? And did you review that with your client?
I did, Your Honor.
The court will find that the state is in compliance with discovery. Mr. McIntyre, I'm showing you what's entitled true bill of indictment. Did you review that document with your attorney? Did you understand it?
Yes, ma'am.
State, are you proceeding on the, I'm sorry, defense, do you waive the reading of the indictment?
Yes, Your Honor.
State, are you proceeding on the indictment as presented?
Your Honor, the state's proceeding on the lesser included offense of assault, bodily injury, married or cohab.
Any objection?
No objections, Judge.
Mr. McIntyre, I'm showing you what's entitled court admonishments and defendant's waivers and affidavit of admonitions. Did you review that document with your attorney? Did you understand it? And did you electronically sign it in all the appropriate places?
Yes, ma'am.
Did you understand the state is proceeding on the lesser included offense of assault, bodily injury, married, or cohabitation? That's a Class A misdemeanor. The range of punishment is up to 1 year in the Bexar County Jail and up to a $4,000 fine. Did you understand?
Yes, ma'am.
If you have a plea bargain agreement with the state, the court does not have to follow your plea bargain agreement. If for any reason the court does not follow your plea bargain agreement and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine any witnesses the state would call, and a right to remain silent?
Yes, ma'am.
Did you understand by entering this plea bargain agreement, you were giving up those rights?
Yes, ma'am.
And did you intend to give up those rights and enter into a plea bargain agreement today?
Yes, ma'am.
Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty, sentence you up to 1 year in a Bexar County Jail and up to a $4,000 fine?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses to this offense?
She has, Your Honor.
Do you
I mean, he
believe,
has.
do you believe he has a rational as well as a factual understanding of the charges against him?
Yes, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Mr. McIntyre, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Has anyone promised you anything other than the plea bargain agreement to get you to enter this plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Showing you the plea bargain page. Did you review that page with your attorney and did you understand it?
Yes, ma'am.
According to the plea bargain agreement, there's a $750 fine. The state is proceeding on the lesser included offense of assault, bodily injury, married, or cohabitation. They're recommending deferred adjudication. There's an affirmative finding of family violence in the BIPP course. Did you understand with an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition?
Yes, ma'am.
Did you understand with an affirmative finding of family violence, you're not allowed to be designated as primary custodial parent?
Yes, ma'am.
Did you understand that to be the entirety of the plea bargain agreement?
Yes, ma'am.
Defense, is that the plea bargain agreement?
Yes, Your Honor.
State, is that the plea bargain agreement?
Yes, Your Honor.
Next, I'm showing you the paragraph entitled waiver of appeal paragraph. Did you review that paragraph with your attorney? Did you understand it? And did you electronically sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, have there been any such motion?
No, Your Honor.
Next, I'm showing you outside the plea bargain agreement, the state is requesting that your deferred adjudication be for a term of 2 years. There be 100 hours of community service restitution, no contact with Karen McIntyre. Did you understand those are recommendations from the state and the court does not have to follow those recommendations?
Yes, ma'am.
Then to the offense is charged, to the lesser included offense of assault, bodily injury, married cohabitation. How do you plead? Guilty, not guilty, or no contest?
No contest.
State any evidence to support the defendant's plea?
Yes, Your Honor. At this time, state offer states exhibit number 1 and its attachments.
Any
No
objections?
objections, Judge.
Mr. McIntyre, I'm showing you what's entitled waiver and consent to stipulation of testimony and stipulations. Did you review that with your attorney? Did you understand it? And did you electronically assign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to a jury trial and the right for you or your attorney to cross-examine and confront any witnesses the state will call and the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there will be no live testimony.
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments. The court has reviewed the same. The court is finding there is sufficient evidence to find the defendant guilty of assault, bodily injury, married, or cohabitation, but will defer finding of guilt as the defendant has applied for deferred adjudication. Are you proceeding with sentencing?
Yes, Your Honor. There were a couple of things I wanted to discuss on the sentencing, though.
Yes.
One is the no contact order. My client is still married with the complainant. They have 7 children together, Judge. I would ask if this honorable court would consider a no harmful injurious contact order for now. And secondly, on the term of probation, the state is requesting a 2-year term of deferred. My client has assured me he can get everything done within 6 months, and it's asking for a lower probationary period, Judge.
All right. Mr. McIntyre,
Yes, ma'am.
was Child Protective Services involved?
No, ma'am.
All right. Are you employed?
Yes, ma'am.
What do you do?
I'm a commercial realtor.
Okay. If you're drug tested today, what are the results going to be?
Negative.
All right. This is what the court will do. $750 fine, that will be probated. There's an affirmative finding of family violence. The BIPP course. Mr. McIntyre, do you live by yourself? Where are you living?
I moved into an apartment by myself.
Okay. 2 years deferred adjudication. There should be no contact with Ms. McIntyre. And that's Karina McIntyre. Parenting classes, CPS compliance if applicable, 100 hours of community service restitution. 40 of those hours will be waived if you provide proof of the COVID vaccination. Court is not requiring you to do the COVID vaccination, but if you do, 40 of those hours will be waived. Proof of employment within 30 days. There is to be no employment as a home health care provider or with minors. You must complete the parenting classes. Once you complete the parenting classes, the remaining hours of your community service restitution will be waived. Regular reporting by Zoom or in person. There's to be regular UAs, or you can do the patch. Field visits, regular 1 time per month.
You say I have to do UAs?
Yes. And field visits, regular 1 time per month. And Mr. McIntyre, once you've taken some family violence classes, and if Ms. McIntyre wishes to have the order lifted to no harmful or injurious contact, the court will consider that.
Judge, will this court also consider an early termination application if he gets everything everything done ahead of time?
I consider everything that's filed, Mr. Nahara.
Certainly, Judge, thank you.
Sure, there's to be no unsupervised contact with minors. Rebecca, is there anything else that he needs?
You say with
Okay.
minors?
With minors, minor children, no unsupervised contact.
Can I ask, I mean, what does my kids have to do with anything? I'm just asking. I don't
Okay, no.
understand.
I mean, I've read the police report, Mr. McIntyre, and in the police report, you injured your wife. So Karina had a large cut near her left eye. I could see blood around the wound and flowing down her left cheek. And all of this started over the fact that one of Jaylon had upcoming surgery.
That all that, I'm sorry, all that information that y'all got I haven't said nothing. Nothing was given from me. I mean, I hear what you're saying,
Yeah.
but that's hearsay. That
So,
ain't come
Mr.
from me.
McIntyre, here's what I always tell everybody, and I always
Yes,
try
ma'am.
to do it myself because I think it makes things work better and people know that you're listening.
I'm listening.
Not only do you have to hear what people are saying, you have to internalize it. So where we are now is that you have a case that's a family violence case.
Mhm.
It's been reduced to a misdemeanor. We shouldn't even be here because what happened should never have happened. Like you shouldn't be living in your apartment because you and your wife and your 7 children should be able to sit down and have civilized conversations with each other without it turning into people throwing lamps or people yelling or violence happening in the home. Now, when violence happens in the home, whether or not you want to take that back now, you can't take it back because it happened. So when violence happens in the home, guess what? Children know about it. They want to know why mom has this cut near her eye. She can be dishonest with them and say, oh, it was an accident. Or she can be truthful with them and say that the father threw the lamp at me and hit me. So we are where we are. And these are the court's conditions. Now I'm showing you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that document with your attorney? Did you understand it and did you sign it?
Yes, ma'am.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition. Do you understand?
Yes, ma'am.
All right, so I'm going to send you to breakout room number 4. Probation will go over conditions with you. Mr. Nahara, you can go to number 4, or either you can be excused.
Thank you, Your Honor.
Yes. All right, we'll go back on the record on Ms. Flowers. Who's your next witness, please?
Walter Clements III, Your Honor.
All right, if you could come forward and take the witness stand, please. Could you raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, you can be seated. State your name for the record.
Walter Clemens III.
All right, defense.
Thank you. And how do you know Anitra Flowers, sir?
I am Anitra's oldest brother.
All right. And are some other family members of hers sitting about 2 pews behind me?
Yes, sir. One of our other brothers and my mother, or our mother.
And your mother's very upset about all this?
Yes, sir.
What did you know about Anitra and Isaiah back in 2018?
Well, as my sister stated, no relationship is perfect. And she did say that there was never any police involved in the relationship. But I can attest on my part numerous occasions. So I shouldn't say numerous, but a few occasions. She did call me to try to de-escalate the situation. For the reason she said earlier, Isaiah outweighed her by almost 100 pounds. she felt a little unsafe and she wanted some assistance in, again, de-escalating the situation.
And do you have any knowledge of why Isaiah would get upset?
I'm sorry?
Why, do you have any knowledge of why Isaiah would get that upset?
There was a number of reasons. One of the main things that stick out to my mind is I helped my sister get a car, so she was able to move around, going to school and work, things of that nature. And at times, Isaiah wouldn't be too happy about that. He wanted to keep her, around him or near him, or, and the way I felt, being a man who's been in a relationship for so long, try to use that as a form of control. And I think that may have been an issue leading up to this. Again, like she stated, she just started school. And she had a gainful employment, things were looking up for her. And I feel that maybe, he might have felt away about that. Not being able to control her as much because she was stepping on her own, doing her own things.
Do you know if Isaiah had asked Nidria to pick him up from work that day prior to any of this harmful incident?
We object to hearsay.
Well,
Sustained.
not that he knows.
Sustained.
Okay. What does your family want for a Nidria from the judge?
As my sister stated earlier, we would ask humbly for leniency here. My sister is a hardworking, caring, family-oriented person who would give her last to anyone that I'm sure Isaiah's family would attest to as well. Things were finally moving forward for her. She hadn't had the easiest childhood. Like I said, things were moving forward for her. She was starting to see light at the end of the tunnel. And we would just hope that somehow, some way, we're able to get back on that track again. I know it'll be difficult, but 20 years would be difficult to come back from that just as bad as it's going to be, or worse than, but it'll also be rough, for a shorter period of time. But we just ask for that leniency because she still has a chance to make this right, move forward her life with her family and her child. And we just like to get back on that track. It was a terrible incident that occurred. No one wanted it to, but at the end of the day, my sister made a wrong decision who she brought with her. But when you got a man weighing over 100 pounds and you're unable to get, I'll weigh you by 100 pounds, and you're unable to get the closest circle you can with you to go try to resolve the situation. Again, she may have made the wrong decision there, but she definitely didn't say shoot him. I know that. That's not the sister I know. And under any circumstances, she never asked me, "Hey, I need to come, set them straight. I need you to come make this right." Nothing like that. You just, "Hey, can you come talk to us? Can you come try to help us figure this out?" It was never anything over the top or violent or anything like that on her behalf. I'm sorry.
Okay. Anything else you want to say to the judge?
If I can speak freely, again, as a man, being in a relationship for a long period of time, there are moments when it's just go over the top that you have a chance to say enough is enough. And by him being the one, okay, even if she did come to his house, he could have stayed inside. He didn't have to go outside. No one had to even, get involved with all this nonsense. It's simple as calling 911. He chose to go out there. His family chose to go out there with him. They chose to call her as she was leaving. He chose to go to the side of the car instead of saying enough is enough. I've proved my point, and it's a tragedy. Again, no one wanted anybody to lose their life, but I know for a fact my sister set everything up, and I know for a fact my sister did not go there with intentions to end anyone's life.
Okay, thank you, sir. I have no further questions. I've asked the witness.
Nothing from the state, Your Honor.
All right, thank you.
That concludes my presentation, Your Honor.
All right, state, the court will hear argument.
Yes, Judge. On September of 2018, a 24-year-old man's life was completely lost. And it's a tragedy, Judge. And even more so, the murder took place in the front yard in the street in front of his mother, his father, and his sister. They watched Isaiah get gunned down in the street. He died there in their arms. And they had to watch that. And now that's what they're left living with, Judge. It's a tragedy. He's 24 years old. He is, he's lost the rest of his life. Miss Flowers is young too. However, there's no consolation for that purpose because the only reason that James Johnson shot Isaiah Roper that night was because of her. She's the connection between them two. Mr. Johnson doesn't show up to get involved or whatever he was there to do unless Miss Flowers is there. I don't think she wants to take responsibility for that, Judge. She's acting like, I don't know, this thing just happened. To me, it sounds like they showed up with a knife and a gun at someone's house in an altercation and someone ended up dead. That's not the surprise that they're trying to tell you that we just showed up and all of a sudden it got to this point. They showed up with weapons, with guns, and someone ended up shot and dead in front of their house. Judge, I believe a lot of what she's telling you is that she wants leniency because of her future. She stole all of that from Isaiah. Isaiah's never going to get to do any of these things. And this is because of Miss Flowers and her choices on that night. And I don't believe she's taking responsibility for that. Judge, she has been given a plea deal of no more than 20 years. I believe you should give her 20 years and give her every day of that because she's already received considerable consideration from a 99 years of life that she was facing up to on this case. Ultimately, Judge, she is responsible for this. She is not taking responsibility for what happened. We've heard that this is Isaiah's fault. This is Isaiah should have done differently. We have yet to hear anything regarding what she should have done differently. I believe she knew that there was a gun in that car with Mr. Johnson. In fact, in her statement, which you have in the stipulations here, during the statement, she says that James told her he was going to shoot him, but she didn't think he had a gun to shoot him anyway. She shows up with a knife. She shows up with a person she knows has a gun, and someone ends up dead, Judge. That's a murder, and under this, the laws of this county, and because of what happened to Isaiah Roper, we're asking for 20 years in prison for Miss Flowers, and we ask that you give her 20 years.
All right. And defense, before you start your argument, I want the record to be clear. Defense exhibit number 1, that was admitted at the trial, the ring video, and the court has seen all the video from trial, but the court did inspect defense exhibit number 1. And this is information that the court viewed at trial, but the court did view it again in chambers. Defense?
Thank you so much, Your Honor. I agree with Mr. Groomer that this is a tragic situation, not only for Isaiah and his family, but for Deidre and her family. She did say she wished she had just changed the locks. I think City Roper is being extremely charitable to recommend that she gets the minimum. And of course, we would be glad to go along with that if the court takes a fair sentence. But if not, I ask that you not assess a term of more than 10 years.
If I could just briefly, for clarification purposes, Cindy Roper did not suggest the minimum. She says sometimes she thinks the maximum, and at times she thinks the minimum. I don't believe she suggested the minimum as her takeaway during her PSI, just for clarification, Judge. But you have it in front of you.
All right, thank you. If there's nothing else from either side.
Oh, Your Honor.
None from the state, Judge.
Okay, thank you. All right, then the court will set your punishment at 18 years in the prison. Give you credit for any time served. There's an affirmative finding of a deadly weapon. I'm going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that document with your attorney and did you sign it? Ms. Flowers? All right, for the record, Mr. Hayek, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your client?
Yes, I did, Your Honor.
All right, and it appears that our signature is on this document. Ms. Flowers, because this was a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Good luck to you.
If I may, we do have one victim impact, if that's possible.
All right, yes. Courtroom. I'm going to place you on mute. All right, and while she's doing that, any attorneys? Abelard or Garza, who do you have? I'm sorry, Brenda, could you unmute? Sorry, courtroom, could you unmute, please?
Judge, I have.
Just one moment, Mr. Abelard. To the courtroom, it appears that Ms. Flowers does not wish to take part with victim impact. So to the deputies in the courtroom, if there are security issues at play with doing a victim impact, then to the complainant's family, I'm sorry that no victim impact will take place. So to the courtroom, you're on mute. Is there an issue?
It's doable, Judge.
All right, thank you. All right, Mr. Garza.
Judge, I have a Cassandra Villanueva, and I guess we're going to plead to a violation.
All right, we're going to have you come back at 2 p.m.
Okay.
All right, we'll see you then.
Sounds good. Thank you, Your Honor.
You're welcome. James.
Let me just tell my client.
Yes, Judge.
Yes.
I've got Roberto Martinez. I have not been able to get a hold of him. His phone is disconnected. I do have, the state is recommending pretrial diversion, and I can continue to try to get a hold of him, but I haven't had such luck.
All right, so that's Roberto Martinez.
Yes.
All right, Ms. Ferguson. Roberto Martinez, Mr. Hunt, I'm going to give a 30-day reset for pretrial diversion. I'm going to note in the file that he hasn't appeared. So if he does not appear at the next setting, a warrant may be issued, okay?
Thank you.
All right, Ms. Ferguson, can I have a 30-day reset, please?
Unknown caller.
All right, we're going to come back on May 23rd.
Thank you.
You're welcome. You're excused.
May I be excused?
Yes.
Thank you.
And Brenda, you can go on your break. Sharon Thorne.
She was having issues with her computer, Judge. I think she's trying to unmute.
All right, so everyone will be back at 2.
And Judge, she's just here to meet the inmate. She's going to be the new attorney.
Okay.
Judge, we're ready on our sentencing, so we'll be back at 2 o'clock. Is that correct?
Yes, and we will take you up, okay?
Good enough. Thanks, Judge.
Thank you.